Welcome to Good morning, everyone. Welcome to the fifth in a series of webinars put on by the Jamaica Developers Association in association with all our wonderful sponsors. We are blessed today to have no less a person coming to join us than our most honorable Prime Minister, who will give the opening address. But to get us going, let us say a small prayer. Omnipotent, omniscient, omnipresent God, unto whom all hearts be open, all desires known, from whom no secrets are hid. Cleanse the thoughts of our hearts by the inspiration of thy Holy Spirit, that we may perfectly love thee and worthily magnify thy holy name. To get us going, amen. To get us on the way, we have a wonderful moderator, Mr. Christopher Honeywell, attorney at law. He's a corporate lawyer with experience of over 30 years in civil and commercial litigation. He's a graduate of Excelsior High School, UWI Law School. He gave back to his country as Assistant Crown Counsel in the Attorney General's office. Later became a partner in Clinton Hart and Company. He gave back some more to our country as Managing Director of the National Housing Development Corporation, now the Housing Association of Jamaica. He is well suited as having such experience in development for this role. And he is the president of the Excelsior Past Students Association and currently chairman of the Vauxhall High School. He is a family man of four children and active father. Welcome, Mr. Honeywell. Thank you so much for taking on this role.
It is indeed my pleasure, Mr. Wood. Thank you very much for that introduction. Sadly, I'm no longer the president of the Excelsior Past Students Association, but perhaps in time again, who knows? Nevertheless, I want to wish all participants to this very signal event, whether they be presenters, panelists, or viewers, and to wish you a great day. I think that this fifth iteration of this event surely makes the point that this is now certainly a calendar event that practitioners and professionals in this industry can look forward to. The JDA and its sponsors has arranged this virtual feast of information, and it generously will share all this information with what I think is a very fortunate audience today. Fortunate, one, because of the quality of information that you will receive, but also for the fact that it is entirely free, which in and of itself is not an indication of the quality of what you're getting. It's a quality of the caliber of sponsorship that our very generous sponsors has put to and supported this seminar, webinar with. We have some very distinguished presenters lined up for you. And we know that the persons so gathered will find this event, which is set to last for the next 3 to 4 hours, to be well worth their time. As Mr. Wood has said, we are esteemed and honored to be able to have as the patron of this particular iteration of the event, and to have the support of none other than the Prime Minister of Jamaica himself. We are pleased to welcome the Most Honorable Andrew Michael Holness, Prime Minister of Jamaica, who was steadfastly. Are you hearing me very well? Yes, who are steadfastly focused on building partnerships to achieve the vision of shared prosperity for all Jamaicans through inclusive economic growth and meaningful job creation. Leading an agile and responsive government, the Prime Minister is committed to making Jamaica the place of choice to live, raise families, do business, and indeed retire in paradise. Ladies and gentlemen, we now have the distinct pleasure of introducing for you the Prime Minister of Jamaica. It appears that the Prime Minister might not be quite ready just yet to join us. I understand that there might be a few technical glitches that he's experiencing on his end, which will resolve themselves shortly. I would therefore like to ask us to look forward into what is lined up as a series of presentations for today. The opening batsman that we have today is going to be a well-known and distinguished attorney, Mr. ALTON Morgan, who over 40 odd years, 44 in fact, has developed a body of knowledge which is enviable to most organizations, let alone most persons. And he has distinguished himself as a salient authority in the matter of all matters to do with the land law. He's going to be giving us, as it were, a part two, a continuation presentation as he analyzes the import, the content, and the effect of the not so new now, but relatively new Building Act. He would have some time ago made made another presentation on this, but these half an hour or 45 minutes that are given to these presenters are never usually enough to allow for this kind of deep dive. And he's come back, and I look forward to that presentation. It is going to be a virtual do's and don'ts of what developers and other practitioners in this sector should or should not do. The fact of the matter is that the new act has changed the playing field in some very fundamental ways. And I believe that there is a knowledge gap between what the new act requires and what old-time practitioners are accustomed to. And it therefore behooves us to listen and very carefully to what Mr. Morgan has to say on this score. So that will be our first presentation. And how we have structured the webinar is, after the presentation, there will be a panel of very knowledgeable professionals or practitioners in or touching the contents of the presentation, and they will lead off comments and field questions on the contents of or surrounding the presentation. So we will have persons of the ilk of Ms. LICEA-ANN Smith, who's a partner and attorney in the law firm of Nunes, Scholefield, DeLeon, who will be one of our panelists, and she will be following up on ALTON's presentation and adding her astute perspective to that whole area of evolving new law. Mr. Zachary Watson will also be another presenter. He's a structural and civil engineer, and he's attached to Peter Jervis and Associates Limited. He too will have something to say on that matter. We're going to have also another presentation, another substantive presentation by Mr. Ian Bennett, who is one of the top dogs, if you may, at the NWC. And his presentation, I think a lot of people who aspire to or who are in development will find and have keen interest in, because he will be pointing the way as to the availability and how it indeed you should access water and sewage services for new developments. The truth of the matter is that this is well, not the sewage that is unlimited, but water is certainly a limited and dwindling resource. And developers and practitioners in the area have to pay keen attention before they make developmental decisions as to where they locate those projects, bearing in mind the availability of potable water. And there will be, again, a series of panelists that will be weighing in on his presentation. People like the very distinguished Dr. Christopher Burgess, who is the Managing Director of CEAC. So it seems that we are now ready to. No, we're not. It seems that the PM is still not available to us. So because we are in the business of multitasking and making decisions on the fly, we are going to change our line of our order of business, and we are going to ask Mr. ALTON Morgan to make his presentation at this time. If and when the PM is able to, he will join us. Now, ladies and gentlemen, as I've said before, Mr. Morgan is an attorney of over 44 years experience. He's actually an associate member of the Jamaica Developers Association himself and has been so for 20 years. He's on the National Land Agency Advisory Board, the Jamaica Chamber of Commerce Legislation and Regulations Committee, the Land Divestment Board. He's a legal advisor to the Jamaica Developers Association, and he's attorney for several of the larger developers. It is really my distinct pleasure, ladies and gentlemen, to introduce to you one of the legal lights and luminaries in my profession, Mr. ALTON Morgan, to give his presentation.
Thank you very much, Chris. I'm indeed overwhelmed. I've never been flattered in so many words by a colleague. But it is, in fact, my pleasure to be back here again this morning. I'm going to share a screen with you so that you can see my PowerPoint presentation. And in that way, it will make it much easier for all concerned. Good. We're going to be looking at the extent to which the Building Act of 2019 affects project approvals, but we'll be doing so in a very special way of relevance to developers. The elements of the statute we looked at in the very first presentation, which was a year ago, October of last year. What we are going to look at now is how it has evolved in its early years, especially in the context of decisions made by the court, which will help us to interpret and understand the operation of the new Building Act. So we start with recent publications and commentaries and analysis of the development approval process have suggested that the regulatory mechanism is tuned to a particular station, WII-FM, which is causing it not to function as it should. I'll explain at the end of this presentation what is WII-FM. So this presentation, therefore, will look at some of the statutory pitfalls and external elements which can affect building approvals, especially for multi-unit developments, whether residential or commercial. So let us start with buildings and temporary structures. The definition of the building under the statute means even a domestic building, as well as public buildings, residential buildings in the warehouse class, and so on. And it says whether a temporary structure or not. What that means for developers is that the temporary structures which are to be erected on a construction site for development come within the definition of building under the Act. So the worksite shed, which is made of wood, or even the trailer, which is brought onto the site to be occupied as a building, because generally it tends to have office and storage and sanitary facilities, those should not be erected on the development site until and unless a permit is first granted. There's a practice in development to hoard the site and put the construction office building or trailer onto the site well before the building approval has been granted. That should not be done under the statute. In fact, if you wish to do so, you simply apply for a temporary permit, and that will allow that you can move the construction trailer onto the site or build the temporary construction site structures. It doesn't matter what they are, it requires a permit. What is advisable also is that the plan, which is being presented for approval, should just show those things as temporary structures. So they can, architect or engineer can draw a little box and put storage shed or workmen's accommodation, watchman's shed, and so on. Make sure they're shown on the plan, and it means therefore that you have made application for those structures as temporary structures to be approved. Now we come to a controversial issue of the size of studio units. Recently I saw an advertisement for residential development featuring a studio of 1,400 square feet. That's illegal. And any approval which was given for any studio of that size is technically invalid. It has its foundations in a ministerial order that was made in October of 2015, signed by then Minister Pickersgill, and it is applicably treated for multifamily residential developments. What it prescribed is that a studio should not exceed 400 square feet or 37.16 square meters in size, including the kitchen and the bathroom. And if it exceeded that size, it was to be treated as being more than one habitable room by a formula of 100 square feet over the 400 square foot maximum, for the purposes of calculating adequacy of sewage systems, parking, and all the various other factors, open space, etc. A habitable room is any livable space, so it need not necessarily be just a bedroom, but any livable space, which is not a kitchen or bathroom or storeroom and doesn't exceed 6.5 square meters inside. So the developer who believes that a 800 square foot super studio is going to be a sure sell has to be careful, because if the amount of support, open space, and so on doesn't calculate accurately against the 400 square foot minimum, then the building approval will be invalid. And you may find that if an objection is raised, then doesn't matter that the strata plan has been issued, the strata titles could be at risk of a registrar's caveat, meaning not all the units may be capable of occupation, only some of them. Professionals, financial institutions, realtors who encounter these supersized studios in excess of 400 square feet, you need to be aware of this and be very careful in your evaluation as to whether or not it is suitable as an investment or to be recommended to a purchaser. Planning reports are another feature which have come up. So the municipal authority in October of 2019 issued a requirement for mandatory planning reports, meaning you absolutely must prepare and submit them once there's going to be any development, whether commercial, institutional, residential, or resort, on land areas exceeding 500 square meters or 5,400 square feet. Now that's approximately a quarter acre. And once you're going to have a subdivision development in excess of 10 lots, it requires a planning report. The notification was gazetted, right? It's aimed at improving the efficiency of the development process, being better able to ensure that developments don't have a negative impact upon the neighborhood, and to balance public and private interests. Unfortunately, there seems to have been general ignorance of this requirement among development professionals, which is why I've chosen to mention it. The requirement seems to have been observed in the breach. If you don't prepare and submit one, then what will happen essentially is that your building application really can't be processed, and it also means that your approval may be voidable. Financial institutions should take heed and request to see the planning approval once it is granted. All right, so I've been notified that the Honorable Prime Minister is now available, and therefore I will interrupt my presentation.
Good morning, everyone.
Good morning, Mr. Prime Minister.
Morning.
I was thoroughly enjoying Mr. Morgan's presentation. I don't know why he stopped. I was learning so much from the presentation. Let me thank you for the invitation to address this webinar. And let me say from the outset that the real estate and construction sector of the Jamaican economy is absolutely important to our growth and development strategy. Construction is approximately 8.2% of Jamaica's economy. We note that there has been a slowing down in recent times in construction. Certainly in the last 2 quarters, we have seen a reduction in the growth of the sector, primarily because government spending has kind of slowed in construction. But we are also noticing that there is a slowing down in the number of requests for building permits and applications to the various authorities. And so it tells me, as the minister with responsibility for housing and real estate matters, that the government needs to pay careful attention to this industry. It is an engine of growth for the economy, and there are several issues which are affecting the functioning of the growth engine of construction and real estate development. Let me jump into them very quickly. I'm told that I have 5 minutes to do this, and so I will move very efficiently through the points that I would want to make to this group. Firstly, I think it's very important that the real estate developers organize themselves into a very robust lobby group, and that they speak vocally to the issues of the sector. And I think it is important that the developers invest in public relations as well, to ensure that their side of the development story is told, and that the development story is not only told by one side of the conversation. Government has an interest, obviously, in ensuring that there is order, balance, equity, but at the same time, government must take a pro-growth stance for development. And I've been very vocal in this matter in terms of supporting growth through the built environment. But I think that developers themselves have a duty to properly market what they're doing and to get the public on board to support development. So that's a general point that I wish to make to this audience. The second point is that for several years, we have been, and when I'm saying we, government has been not very clear about development intentions. And I say this because we have had a provisional development order, particularly for Kingston and St. Andrew, which has not been finalized. There are many issues, and obviously the participants in this seminar would know that the finalization of a development order is a very complex issue. I had said in my budget presentation last year that we were targeting June of this year to have the development order for Kingston and St. Andrew finalized. We are a few months off of that target, but this morning I clarified with my permanent secretary and the head of NEPA that by December, the first week in December, we should be in a position to finalize the development order. The development order will give, I think, greater clarity to some of the gray and ambiguous areas in development, some of the areas that have been challenged in court, and some of the areas that are giving developers pause in moving ahead with their development. So, for example, the question of whether or not developments can take place on lot sizes smaller than half an acre, that matter will be definitively resolved in our development order, which will be finalized. The issue of greater density and height, and which areas greater density and height will be allowed, that will be clarified. And issues such as, the definition of a basement, those issues will be clarified. So a finalized development order will give more definition and certainty to the development space, and thereby increase, which is our hope, the number of applications for development. We will also be in a position by December to table the long-awaited legislation for shared communities, better known as the gated communities legislation. That is finally at a stage of drafting where it is just being finally reviewed by the real estate board, and that should come to cabinet in December, and thereafter it will go through the parliamentary process. So that is a bit of good news on the legislative end of things. I wanted to update developers as well on the government's infrastructure drive. So we have, as you know, we admit clearly that we have not moved quickly enough on the legislative side, but I think we're now in a position where the legislative side will be settled. But we have been moving with great speed and alacrity on the infrastructure side, and in particularly in Kingston, going out to St. Thomas, the expansion of the East-West Highway and developments in St. James. We'll be opening several corridors of development, which I'm hoping that developers will be reading very carefully. Certainly for St. Thomas. St. Thomas is, I believe, the new area that developers should be focusing on for housing and light commercial development. We are expecting that the road construction there will be at a substantial completion in another year. And I think now is the time when developers should be seeking out lands in that area and having them integrated into the development that is taking place. We have invested quite a bit of resources in ensuring that the road that is being developed has water supply. So you would see that the entire stretch we have laid significant size in terms of water mains. We have made provision for fiber internet connectivity. And in some areas, there is provision for sewage. So there's everything there in that corridor to support the development of housing. And I would urge developers to move along that corridor and start developing plans for housing. In St. James, the same thing is being done with the development of the Montego Bay Perimeter Road, which is not just the Perimeter Road, it's also taking in the Long Hill bypass. So that entire corridor will be open for development. In Clarendon, with the expansion of the East-West Highway, all of those lands now become possible for housing and light industry development. So I would encourage developers who are in this seminar just to start looking at developments along those corridors. In Kingston, the developments along Arthurwick Drive, Tom Redcombe Avenue, East Kings House Road, Lady Musgrave Road, all of those areas are going to be significantly improved, not just to make traffic flow easier, but more importantly, we will be changing out the water mains and putting in place sewage. So that will allow for an increase in density and height. So developers, I think, should be looking at those areas very carefully and making their plans as to how they can facilitate development in those areas. Suffice to say that the development will not just focus on construction, meaning the laying of the asphalt and the sidewalk and the road furniture, but we want the place to be aesthetically appealing. So the corridor on Lady Musgrave, on Tom Redcombe Avenue, and those other areas, significant resources will be placed in terms of beautifying them. And it means, therefore, that the developments that will be approved along those corridors must have a certain architectural appeal, certain facade, and must add value, not just in the construction and real estate value, but in the aesthetic value. Our city we need to have our city looking good, and not just throw up any building, but the aesthetics of the building will be important. And this would be a thrust for approvals now, both through NEPA and the local authorities, that much more attention has to be paid about how the building looks and how it fits in to the area. I want to quickly turn to the financial side of things and what government is doing to support development. The government has an obligation, international obligation, to ensure that our financial system complies with the international financial standards. And we have made changes for real estate dealers in terms of the compliance for know your customer requirements and for source of funds and for reporting suspicious transactions. When those changes were made, the developers were not captured in that change, but it is now a requirement in terms of us fulfilling our compliance for international financial standards, that those changes will have to be made. Of course, we don't just make changes like that without having proper dialogue and discourse and feedback. So I'm certain that that will be undertaken by the real estate board. I want to close then by focusing on the NHD. The NHD has a very interesting program, which we call the GPP, where the NHD will purchase completed units from developers at a fixed price, a predetermined price. And this is designed to take away the development risk from developers and to take away the market risk mainly from developers. We have seen some take-up, but not enough. We have a target of building 70,000 new houses. The NHD's portion of that is 43,000. They have identified lands and they have identified developers for a significant portion of that, but not for all of it. And the target is to bring houses to market in the price range on average of about 10 million Jamaican dollars. Now, I know most developers will immediately say, that's not possible. That's not possible. I would want to say that with creative and innovative considerations, we should be able to treat with that segment of the housing market. The truth is that for decades since the formation of the NHD, the housing market has focused mainly on providing housing solutions for middle income, even lower middle income. But we have not been successful in providing mass housing for persons earning minimum wage or just above. And that is a terrible market failure, which the government has a critical role in ensuring that that market failure is corrected. So we have redirected the NHD to focus on this area. So it means that the financing from the NHD will be going to support developments that are going to bring houses to market that are closer in price to $10 million. And I would want to urge developers who are on this platform to consider how you can use innovative building techniques or other strategies to bring down the cost of housing to ensure that we are not just serving one segment of the society, but that all members of the society can find a solution to the housing challenges that we have. So with those comments, I want to congratulate the organizers of this seminar and to thank you for the opportunity to address you.
We thank you very much, Mr. Prime Minister, and we did promise you that his presentation would be well worth the listen. It has been a most present discussion, and it points the way in many ways that perhaps developers need to be looking in the next 2 to 3 to 4 years. We are now going to go back to Mr. Alton Morgan. He was halfway through his presentation, and we hope he hasn't grown cold. We'll ask Alton to take up where he left off.
All right, thank you very much, Chris. Fine. So we were looking at planning reports. What I should tell you is that the requirement was temporarily suspended, but it does not mean that the requirement is going to go away. The main reason behind it, in fact, is that proper compliance with our planning requirements does require that specific information be provided about proposed developments, not just blueprints. And in fact, it will help in many ways. When an inquiry is made by neighbors, you can give them a copy of the planning report and they will be satisfied as to what the development intentions are. But let's look now at what has become somewhat of a bone of contention, because developers seem to be unaccustomed to dealing with interference once they have their approvals. And it comes under Section 45 of the Building Act, enforcement notices. So if the local planning authority, which is the municipal authority, is of the view that work is being carried out without a permit, or that any condition on the building permit is not being satisfied, then it can intervene with an enforcement notice. And that can take the form of a stop notice. Notice may require that you demolish certain things or discontinue certain work, or that you carry out specific work ahead of something else that may be planned. It has become of critical importance because the courts have now stepped in. So let us look at one of those instances. In July of 2019, shortly after the act came into effect, NEPA served notices on a developer at 29 Dillsbury Avenue for failing to post signs, not doing tree flagging. There are certain trees that are to be taken down once they are of a certain size and type. And of course, in relation to the hoarding of the site. Because there tends to be a practice nowadays by some developers to hoard parts of the road reservation in order to take the hoarding out beyond the boundary of the land, out into the road reservation, in order to use it temporarily to store materials and so on. So the court issued a stay on the construction permits in October of 2019. Well, the matter ended up being heard in court, and that case was the case of Wintco and others versus the KSAMC, the NRCA and others. And it's reported, for those lawyers who want to look it up, 2022 JMSC Civil 21. You can find the judgment online. It was for the same premises in respect of which the enforcement notices had been issued. Well, when you read the judgment, it was literally a hammering of the regulatory authorities. The court chastised the regulators, who they found were technically breaking the law in approving the housing development. And the court went on to revoke the permits issued by the KCAC and the NRCA. What it found was that the approvals were irregular, but also that during the construction process, no proper checks were done by the authorities to ensure that what was being built, that the development matched what was approved by the plans. And of course, it put the whole thing in doubt of compliance with the building approval. And it's important to note that the case was not aimed at the developers of the property. It was aimed at the regulatory authorities and the property owners. What is crucial about that decision is the assumption should not be made. Well, as I say, you mustn't assume anything as a professional, because, you know, if you break the syllables down, you make an ass of you and me when you assume. One must not assume that a building approval, once granted, is a carte blanche to do what you think you would like to do with a development project. It requires strict compliance. Section 47 of the Building Act actually allows the court to make orders for destruction of buildings. So those who will raise their eyebrows at the thought that once it has been put up, no court can order them to take it down, there is specific provision in the Building Act for it under Section 47. And notice, the order can be made against a person whose identity is unknown, because in many instances we find that developments are taking place, and when you check the titles, there has been no transfer of the land. It's in the name of the person who bought it 30 years ago, and when you check, that person is deceased, so you don't know the identity of who is doing the development. It does not stop the court from making the order required. The court, of course, will enforce it against the owner of the land, the builder, or the occupier of the land where the building work has been carried out. So there's no question of secrecy being involved. If you think that, or if they don't know who we are as the actual developer, they can't make the order, that's not so. Section 47 is extremely wide in its ambit. And of course, courts do not make orders in vain. And the orders can be to demolish or alter the building work, such way as the chief engineer describes, or discontinue use of the land for the building work, or to carry it out in a different way. And of course, to pay costs and expenses or do such other acts as the court considers appropriate in the circumstances. So you really want to be sure, as the developer and as the professional working with the developer, that there is no risk of an order being made under Section 47, because that can be serious. Now, it's not new. Section 47 is a reflection of what transpired before under a somewhat different process when we had the KCAC Building Act. So the power existed and it was exercised in the case of Auburn Court versus the KCAC, which was back in 1996. That involved well-known issue of the construction of a bowling alley on South Avenue in Kingston 10 without approval. And the case went all the way to the Privy Council, which in 2004 upheld the KCAC's enforcement notice that the building could be demolished. And it was eventually taken down by the authorities. Unfortunately, that particular development company was a repeat offender, and it found itself back before the courts again in an action against the Town and Country Planning Authority, which had issued an order under Section 23 of the Town and Country Planning Act for sections of a building in New Kingston to be demolished for being in breach of planning guidelines. So the question of the court making orders for buildings to be taken down has always existed in various forms in other statutes, but there is no specific and clear reference to it in Section 47 of the Building Act. And we have to be very aware and conscious of that. So we look now at something which is relatively common and misunderstood in terms of what you can and cannot put up as a perimeter wall for a development. Perimeter walls require building approval, especially at road boundaries, because they must be engineered to contain vehicular impact, not create risks of falling into the road in the event of an earthquake or subsidence due to erosion. You drive along certain streets in Kingston and St. Andrew, and you will see walls that are leaning outwards towards the roadway because they weren't properly designed and constructed. So when you check the schedules of the Town and Country Planning Act, the Provisional Development Orders prohibits development without approval for specific things. Newly constructed gates and fences and walls adjacent to vehicular roadways are limited in height. So you think you're going to remodel a house and put up a very high wall, be careful. And for developers, be careful of your wall heights. You have to get approval for them. It applies to even other gates and walls which do not face the road. There's a maximum height of 2 meters applicable to it. And of course, they are subject to the law even if you are increasing the height of the wall. So you may be using an existing wall for the development and simply raising the height. You have to be careful not to raise it above the prescribed height. Gates and fences and walls are by the regulations of the National Building Code controlled in their design and components of construction. Any and everything that you feel like. All right, so we come now to party and dividing walls. Yes. Party structures now are the next thing. Now, a party structure falls under sections 58 to 69 of the Building Act. And there are provisions basically which says once you are going to have this wall shared with a neighbor, you have to get approval for it. It includes all sorts of things. Partitions, arches, floors, and other structures separating buildings, stories, or rooms which belong to different owners. So it's not just the external party walls, it's also internal party walls which are affected. And it goes to even where you have distinct staircases or separate entrances from outside a building, which of course you would find applicable in apartments or condominium structures. In essence, you can no longer just simply go and build a wall along a zero lot line that's shared with a neighbor without getting approval and without the involvement of the adjoining owner. We tend to want to think, well, it's my wall, so why should I bother? I'm just going to do what I want to do. No, the Building Act now governs what is technically known as a party structure. Right. The consent of the neighbor for dividing walls and fences. Now, an unusual situation has developed where the newer statute has imported another pre-existing statute into its effect. We always had a Dividing Fences Act, and Section 4 of that law said that as between adjoining owners of property, there had to be consultation for the erection or maintenance of a dividing fence. So the Building Act uses the requirement for consultation under sections 22 to 23 to import the application of the Dividing Fences Act. And essentially what both statutes now require is that one has to invite the neighbor to agree to the dividing fence to be constructed along the boundary line. And you have to agree on the components, what's it to be made of, the dimensions, and of course, the cost. Well, fact is, Section 5 of the Dividing Fences Act doesn't require anything more than a simple post and wire fence for open land, or if you have animals to be contained, a chain link fence. So what if there's something more elaborate? Well, Section 6 of the statute speaks to that. And once it comes to something more elaborate or more complex, then there has to be a negotiated agreement, which should be put in writing, by the way, so that there's no doubt as to exactly what was agreed, because the law does say agreements in relation to land should be put in writing and signed by the parties. But what matters is that walls above 4.5 feet or 1.5 meters in height require building approval. So if there's going to be a 6 or 8 foot wall around the development, the developer has to get the consent of the neighbor. And it should be the subject of a separate building approval, because it's an approval granted to both parties, not just to the developer. Means, therefore, that developer really has to say to the neighbor, we're putting up this development next door, and this is the wall we wish to have erected, this is the features of the wall, and so on, and will you please agree to it? And no, you're not going to have to pay anything towards it. We, the developer, will cover all the costs, and if so, then fine, it should not be a problem. But if not, then your neighbor can take you to court over the development wall, and you may find that a Section 47 order is made requiring you to take it down. We look now at walls below ground level, because it's the same principle. We're looking at walls above ground height, but now we look at walls below the height of the ground. So digging below the level of foundations of neighboring property to put up boundary walls constitutes a party wall structure under the Building Act. And of course, it's now a common feature of construction of buildings with basement parking, whether they be residential or commercial. Once you're doing basement parking and going below, then you need to pay close attention to what the law requires. So the neighbor has to be notified, again under the Dividing Fences Act, pursuant to sections 22 and 23 of the Building Act. And their permission has to be obtained for construction of what will in effect be a retaining wall between the new development and the subterranean area of the adjoining premises. Because remember, land is not just the surface, land is the earth below and the sky above. So when you have a title to land, you own what is below the surface of the land, and you own what is above the surface. And there are rights of support, easements of support, automatic natural easements of support from one side to the other. So if you fail to consult with the neighbor and decide you're going to dig down and put in a basement, then you can end up in problems. And there was a decision in the case of Green versus Cunningham back in 2019, which ended up with the developer being put under an injunction restraining him from the construction of the party wall. And of course, if your building approval requires the basement and you can't put in a basement, then you can have others. But it goes further. The cooperation is important, because the neighbor may have a pit in their backyard, which you don't know about. Most people don't really have a clue as to where pits are exactly in the yards, whether they're to the front or the back, except when it overflows and you have to call the cesspit people to come and empty it. But there are pits which can leach in the direction of the basement, which is being constructed next door in the development. And that can lead to black water seeping through due to inadequate waterproofing, which then becomes a health risk. That was actually one of the issues which came up in the case of Wintco and others versus KCAC, which I mentioned earlier, the Dillsbury Avenue case. So do not think that, oh, well, there's very little risk of it happening. It has serious implications. If you're going to put in subterranean walls, basement walls, you must absolutely consult with the neighbor and make sure you have a building approval for that wall after the neighbor gives their agreement to it. Another issue which has come to the fore is that of stories versus floors. Now, let me explain. Americans call a story a floor. And so they start at 1 for the ground floor and go up from there. But our law separates them. And we have ground floor, and then stories start at the level above the ground floor. So the first story is the first level above the ground floor, not the level which rests on the earth itself. And there now seems to be a question in the design and construction element of new developments of whether a building erected on a slope, which is open at ground level, but is enclosed on other sides and below ground level, has a story at that point or simply a floor. And it did come up in the case of Wintco and others. Notice that case touched on a whole range of issues in relation to the Building Act because it affected the setback of the building and whether or not the construction was a floor, which wouldn't apply to setback, or a story, which would apply, and whether or not there were different levels because they had things which along the slope were set at different levels but were not actual buildings. And the difference is that under the relevant statutes, the setback distance for a story, which is a constructed structure, is different from that of a floor. You can read the judgment. The matter was interrogated in paragraph 74 to 79 of the court's judgment. It's not anything which the courts have not seen before. The courts in the UK actually had to look at that issue. There's a case of Bristol City Council versus Diggs Bristol Limited, which offers some guidance. And in that case, the Court of Appeal in the UK looked at the factors that would determine what is a story vis-a-vis what is a floor, and concluded that if the space was essentially for access and not really occupiable, then it would not be counted as a story of a building, but simply a floor. Which means that if you put in basements along a slope and they're only to be used for storing things or vehicles as for parking, then they are not stories of the building, they are just floors below that level. So we can gain a bit of guidance from that. Okay. Another troublesome area in relation to building approvals, which is emerging, is that of plot to plan ratios, plot being the size of the land, plan being the size of the structure. In the Belgravia development case, read 10 Roseberry Drive, decided last year under the Restrictive Covenants Discharge and Modification Act, the court found that the building approval was irregular because the property size was less than the prescribed half acre. It rendered it unsuitable for multifamily residential development. Consequently, although approval had been granted by NEPA and licenses had been issued, and approval had been granted by the KCMC, both approvals were technically invalid for non-compliance with the statutory guidelines. It comes under a principle of law called, I'll tell you the Latin, omnia presumptio res acta, which says when a regulatory authority does something, it is presumed to be properly done. But if it can be shown that it was not properly done, then the presumption goes, and therefore the validity of the actions of the regulatory authority fall into question. What operated in that instance was Section 12(1)(a) of the Town and Country Planning Act, which says where an application to a local planning authority seeks permission for development which is not in conformity with the development order, then the application has to be referred to by the local planning authority to Town and Country Planning, and it had not been done in that instance. So if the developer wants to use a lot that's less than the minimum prescribed size, or wishes to have more habitable rooms than the plot plan ratio allows, it means that the KCMC does not have singular authority to give the building approval without first referring the matter to NEPA. So you need to ask, has it been referred to NEPA to be satisfied that the correct process under the law has been followed? If not, you may have a building approval which is invalid. And the developer can't really say, well, I didn't know, because the law is there telling you how many habitable rooms you can have based on size, etc., and what is the minimum development size for a lot. It really means that caution has to be exercised to ensure compliance with the law. Well, let's be careful about something now. This business of developments taking into consideration the neighborhood and the neighbors has become of critical importance under the Building Act. And so that's why this is titled Love Thy Neighbor or Fight the 800-Pound Gorilla. And the 800-pound gorilla is not the neighbor, it's the court. The court has the authority by the judicial review process to declare a building approval invalid for want of neighborhood consultation. That standard was demonstrated in the Young and others versus the KCMC and NEPA case, 2020. It's called the Birdsucker case, where the court found that the governing statutes had been breached by lack of pre-consultation with neighbors as required by sections 22 and 23 of the Building Act. And more important also was that in that case, the environmental permits was issued in May 2018 after the building approval had been granted in December of 2017, 5 months previous. So the building approval was unlawfully granted because it was done without an environmental permit. And it was also similar to the Roseberry Drive case in the fact that the lot size was below the minimum size required. One last point, essentially, is that your building approval now has a much shorter life than it did before. Previously, building approvals were valid for 2 full years. Under the new act, it's effective for 6 months or until construction begins. If you don't begin construction in 6 months, you must apply to have it revalidated and pay a fee, which is 10% of the original application fee. And you can't do that indefinitely. It has a maximum of 2 years. Within that time, you have to reapply on each occasion after 6 months to have it revalidated. And after the 2 years, if you have not begun construction, then your building approval will expire. And the need to have that done is that there may be changes in regulations that affect the development, and also there may be changes in ownership of the land. The approval is not transferable. Roadways may have been widened, which can affect setback distances, or roads converted to one-way, which affect traffic flow. And then you may have that public switch facilities may have been upgraded, which would change even the habitable room requirements. So, in concluding, we know that Jamaican proverb that what gone by the morning can't come good evening. The Developers Association exists for a purpose, to ensure that developments are conducted in the best possible way. And the association does have several law firms as associate members who have the knowledge and can give the guidance. You don't have to use them as your attorneys for the project, but you have to make sure that you have the proper guidance on statutory compliance. It means also that every billing approval has to be carefully checked to see if it is properly granted, and that one must adhere to the conditions, because there are complications that can arise to prevent sale of the units, or the court may order that the building be demolished. And of course, that can destroy the developer's reputation. Well, I promised to tell you what that radio station is, WII-FM. It plays in people's heads, by the way, so you can't tune to it. You're not going to find it on any broadcast frequency. And it affects all of us, whether you're developers or not. It's a station, what's in it for me? And it's part of our attitude of how we approach things. So be careful that you don't tune to WII-FM. Thank you very much, Chris.
Alton, thanks for a very insightful, very informative presentation, as always. We're going to cut to a commercial break now, and when we come back, we'll be having a short question and answer session of about 20 minutes or so, which will be led by Alton and some panelists, which I'll introduce shortly. Let's go to the commercial then.
Be fully prepared this hurricane season. Let BCIC Homeowners Insurance protect your home against hurricanes, floods, heavy winds, and other damage with up to 11 months to pay your premium. And you can save 15% when you bundle home and car insurance. Call or visit any of our 8 branches for a quote. For more information, visit bciconline.com. BCIC. Everything we do is for you.
The Jamaica Property Company has conceptualized, constructed, and managed iconic yet highly functional buildings since 1966. A range of clients include residential, commercial, and diplomatic operations across Kingston and St. Andrew, shaping the skyline by pioneering high-rises from downtown to New Kingston to Manor Park. The standard of property management is Jamaica Property Company.
I believe we're back on, yes. Thanks to our sponsors. We are going into a Q&A session that will be discussing the contents of Mr. Morgan's presentation or matters inspired by the presentation. And we have the pleasure of being guided through this session, the expertise of 2 luminaries in the industry. Firstly, Mrs. LICEA-ANN Smith. She's an attorney at law and partner in the law firm Nunes, Scholefield, and DeLeon. She's been in that firm since 2003, during which time she has amassed a reputation and a body of work that distinguishes her as an expert in the field of estate planning and conveyancing. She is the firm's representative on the Jamaica Developers Association and the and the private sector organization of Jamaica. She's also, of course, a member of the Jamaica Bar Association. She comes to us with a wide range of experience that she has gathered over many years of conducting sale and purchases for real estate, and during which time she has had to come to satisfy or solve several complex legal issues. So she joins us from the legal side. From the more technical side, we'll also have Mr. Zachary Watson. He's a structural and civil engineer, and he works for and is attached to the firm Peter Jervis and Associates Limited. Mr. Zachary Watson has practiced as an engineer for only 3 years now. So he's quite a pup in the business in terms of years, but he has had quite a range of experience in his 3 years. That, you know, they say it's not the life in your years, it's the years in your life, or how it goes, Alton. You're good at these aphorisms. I forgot.
You were correct. Yes.
Yes. So he definitely has a range of experience that coming out of UWI and having achieved his bachelor's in civil engineering, he has now steeped himself in the practice of engineering and will, I believe, cast a certain perspective on our deliberations today as we consider the impact and purport of this new building act. I am going to perhaps set the tone by asking each of the panelists to maybe have a quick 2-minute comment on the presentation and their perspective on it, and then to lead off into questions. Leisha, can you go ahead, please, ladies first?
Okay, thank you very much, Chris. ALTON, again, great presentation. Of course, you've provided us with all the relevant information, especially a lot of food for thought. One of the things I would say is that the legislation does provide sufficient information for developers who want to undertake their developments. I think what has been lacking over the years and even now is the enforcement of the provisions. And maybe what it means is that those who are tasked with the responsibility of granting their approvals need better education or need more training so that they themselves don't run afoul of the law. Because a lot of the court cases that you mentioned, what you'll find is that they did not adhere to the process that is right there in the legislation. So maybe there needs to be greater training or something so that they themselves are aware of what is required, and then to hold them to that standard to make sure that everything is done in accordance with what the law provides.
I agree with you entirely, Leisha.
Further to that point, Lisa, yes, it really is a breakdown in the regulator body. As Mr. Morgan pointed out, most of the court cases, even when the court ruled, it was not directed to the development team, but mostly to the regulator body. And you can see that even in your conclusion, he said, what gone would have gone in. Yeah, so it's mostly designated to the regulatory body. And, you know, you made a lot of good points in regards to the partition walls, the basement walls, and especially what is a main issue now is the differentiation between the floor and the story, because that's mainly a loophole that is really being targeted right now. So you made a lot of good points, and I made my notes, and it was a very good presentation.
Yes, Alton, I'm noticing that there are quite a few questions that we have. Some of them have been upvoted and they have quite a bit of support. So I'm going to throw one at the panel. Feel free to answer. One is from Mr. Jeffrey Stubbs, and it says, I would respectfully suggest that the building code be made accessible via internet. It's a very critical document, which is way past due, and thus it should be easily accessible by all. Currently, one has to purchase it from the Bureau of Standards for approximately $8,300. What say you?
I think the price is cheap.
Yeah, I'll agree. And firstly, it's actually not the code, it's actually the act, because the official code is not out as yet.
Right.
And if you even look across the board, globally, in the American or in the UK, you have to purchase those the disciplinary bodies have to purchase those codes and those acts. And as Alton rightfully said, the price is fairly cheap for the knowledge and to save the court case and the hassle. I mean, it's the law.
Yes. There's a
May I just say something,
Sure.
sir? Because while it may be cheap, I think at the same time, we have to balance the situation in that the general public who we want to assist throughout the process as well, so that we don't have purchasers buying into developments that later have issues. We need to have some form of education then. So maybe not the entire legislation or the building code perhaps, but some kind of information that is easily accessible, free of cost, that at least points them to where they need to go to ensure that they are compliant with the act.
such as this webinar. Point of
Right,
fact.
this webinar is free.
You speak of the training of the regulators. Isn't it the truth though that having regard to the breadth, the extended breadth of the matters that are now covered by the Building Act, as ALTON has put it, really only the dog kennel and perhaps a very low fence that you can step over is excluded. Everything else is subject to some kind of a building approval. Do we actually see a commensurate development within the regulatory bodies where they're building capacities to actually go out there and cover, or upon receipt be able to quickly analyze and deal with what should be an entirely different and greater amount of applications?
Well, what I will say is that the income which has been earned by the local municipal authorities on the surge in applications over the last few years should have provided them with sufficient resources to engage the necessary technical skills, especially inspectors, for example, to go and inspect the various sites. There are retired architects, retired engineers who can easily perform that task. The job can be outsourced to them. So when I hear the complaint of lack of adequate technical staff in the local planning authorities, I think it's really a question of them not making the effort to find the solutions to it. But the dangers which are created by non-compliant construction, where it does not comply with the actual building approval, I think those dangers are so great that every effort should be made to ensure that the technical personnel are made available to monitor the construction.
Absolutely. There's another question here I'm seeing from somebody who's a little bit hardened and perhaps cynical about how things are. It's Sandra Forbes, and it says, what happened to the regulators in the Birdsucker case? Were they fined? Was the developer compensated as he was given approval from the regulators? You understand the question?
Yeah, I understand it perfectly. We have a lacuna, a gap in our systems where the entity which gives approval employs persons. You can't sue those persons and you can't claim damages from those persons directly. It's the entity that you deal with. So it's left up to the entity to sanction those persons who were careless in giving the approvals. It's as simple as that. We just have to deal with the specific entity.
Noted. ALTON, there's a recurrent theme in some of the questions. I believe you addressed it, I think, adequately in your presentation, but there seems to be some question mark and blur as to the
Studio size.
The studio size. Could you go over that slowly?
Oh,
so
yes.
that
All
very
right.
clear?
So,
is it 400? Is it 600?
I think it has been adjusted from what I recall up to 600 square feet. The fact is it started out at 400. My understanding from speaking to the minister at the time, this was back in 2015, and I spoke to him not only as minister, but as a colleague. There was great concern over the expansion of units in the St. Catherine area, which had been built as studio units, and they were being added to by putting on upper floors and so forth. The infrastructure could not accommodate that level of expansion. because what you had were development units meant to hold 2 persons or maybe 2 adults and a child, and they were now holding 5, 6 people, entire large families. So he thought it necessary to issue the ministerial order saying, look, this is what the size of a studio is. If you're going to have more than that, then your support infrastructure and your external facilities, open spaces, etc., have to be adjusted as if you were building larger units. So it's not really a question of the unit size per se. It is a question of whether the external support facilities, parking, open space, sewage, even electricity supply is an issue. And I recall we had a meeting, the Developers Association, along with the other participants in the development industry, had a meeting with Minister Vaz a few years ago. And he made that point very clear to us, that because government was responsible for infrastructure, we could not have an overloading of the infrastructure by having these larger than normal units, which accommodated more persons than they were intended to accommodate. So the focus really should not be on the size per se, but the number of persons that they're likely to accommodate.
Okay. There's a question from Gregory Mayer, which seems to challenge, I believe, the conventional wisdom underpinning one of the provisions that you highlighted, Alton. It says, how can an approval be valid for only 6 months when after approval you have to go through a process of amending covenants, sometimes approach the market for pre-sales and apply for bridge financing from a bank? A practical question from a practitioner.
Oh, with all of what is involved, there's a tendency to treat the approval as the primary objective. The secondary things which have been mentioned should come before and not after the approval. So if you're going to be modifying a restrictive covenant, you should be consulting with the neighbors, and the same consultation with the neighbors for the building approval requirements is the consultation that can take care of the modification of the covenants. You can actually get the neighbors to sign a consent or a no objection, which can then be provided to the court, and it will smooth the process. So the matter of which comes first has been much understood over the years. What comes first now under the ethos of the new Building Act is make sure that you are not going to have any objections from your neighbors when you do the development. Because all the cases which have been brought, challenging developments, have been brought by the neighbors. And that's the essence of it. You know, it's a community change that you're going to bring about, and you need to consult with those persons before you set about to change the community.
Hence your exhortation, love thy neighbor.
Precisely, sir.
Keep them close to your chest. There's another one here. I'm sorry, go ahead. Somebody speaking? Oh, Marlon Mendez asks, good day, very informative session. The PM spoke about increasing density in the Kingston area, but what about the traffic challenges? Any plans for traffic management? Not quite sure who here can answer that, but it's a question that has enjoyed quite a bit of support and voting, so I'm putting it out there.
Throw that one at Zachary.
It would be nice if somebody from the NAA or the government would be on to answer that one.
Yeah.
There is need for traffic improvement, but that now lies within the government. But I do agree that there is need for traffic improvement, especially with the aesthetical appearance that the PM wishes for Lady Musgrave Road, which is our main corridor that experiences a lot of traffic.
And if I can just add to that, what I would say is that that's why things have to be looked at holistically, because everything is interlinked. You can't put up a 100 or 10-story building and expect that traffic is not going to be impacted. So even in terms of the whole approval process, it must be taken into consideration before approval is granted for something like that. And you have to look at the traffic flow. You have to look at the effect on the amenities, such as the water, especially. In this environment where we're not getting as much rainfall as we used to, what other provisions can be put in place? How is the government making provision for that, so that this infrastructure that they are trying to put in is done in a timely manner and can therefore support the construction that we want so much to take place? So it has to be looked at holistically.
Right. Well noted. Sandra Lynn is asking, I believe, almost from the real estate salesperson's perspective, anything on reducing sales in US dollars and demanding payments in US dollars? Purchasers are suffering with this. Hope something can be done about this, where the Jamaican dollar option is it can be at least allowed as an option to the US dollar. Anything on this, councils? What is legal tender in Jamaica? And are these contracts legal?
Let me help you with that. Our Bank of Jamaica Act is very, very clear on it. The only proper legal tender in Jamaica is the Jamaican dollar. We have seen the so-called US dollarization of the real estate industry only in a particular market segment. There's a specific market segment that has been shifted into US currency as sale and purchase price and rental in some instances. And I think that that is a very small percentage of the overall market. The statute speaks to it. It allows that persons can make contracts in foreign currency if they wish. The only limitation being that you can't require the payment of any local tax to be made in US dollars, because local taxes can only be collected in Jamaican dollars. Therefore, things like transfer tax, registration fees, stamp duty, and so on cannot be collected in US dollars. It's unlawful to do that. But you can have your purchase money paid in US dollars.
There are a few questions that have a common theme, I believe. They're really responding to and following on the suggestion that was made earlier, certainly by you, Alton, that funds have been collected in the various agencies, local government agencies, so that they can actually put the structures in place to do the type of monitoring and evaluation that they need. And for instance, Jermaine Rayner and Gilroy English are asking whether or not that is happening in any systematic way, and whether or not there's a recognition that having collected people's monies for these applications, that they're collecting it so that they can use those monies to monetize rather, and finance the examination over time of the works as they unfold, and ensuring that standards are kept. Are they recognizing this in the agencies, and are they actually taking any steps in that direction?
Well, I'm going to stick my neck out on this one, and I'm doing so as a lawyer. There's a principle of legitimate expectation, which is a constitutional right, that if you submit to a statutory or authorized process for permission to be given to you, that those who are responsible for giving you that permission will ensure that they follow the law. There's a Privy Council decision out of Trinidad called Lopinot Limestone versus the Attorney General, which examines that principle. I think a day is going to come when a developer is going to sue one of the municipal agencies when he finds that they failed to carry out the proper inspections and compromise the development, and that lawsuit can be grounded on the principle of legitimate expectation. Okay? It struck me after we had the bird sucker decision, the local planning authority in Kingston and St. Andrew held a meeting at the conference center. And I was absolutely amazed to hear the CEO announce the things they were going to start doing, which were things that were required to be done under the Building Act. Like the posting of notices of the grant of the notice that you were applying, and then the publication of the actual building approval, etc. We must hold the feet of those responsible to the fire. That's my view. You can't have laws without enforcement, and enforcement must come from those who are affected by the law, those who are prejudiced by it. So I fear that a day may come when one of those approving agencies will find themselves facing a very serious and expensive lawsuit because they dropped the ball.
Yes.
If I may just add, I do believe that the authorities have taken great, what should I say, note of the cases, especially those where it has been held that they have been wanting in terms of how they granted their approvals. And I know that there was a meeting which was convened with the Honourable Minister, Desmond McKenzie, with the Jamaica Developers Association, with a view to giving input as to what can be done to enhance the process, and also in so doing, recognizing their limitations where their inspectors are concerned and the overall enforcement process. So I do believe that they've taken note and they are making efforts to improve things, but I guess what I'll say is that they have to put the money where the mouths are and actually do what is necessary to put the structures in place so that it can take place.
Yes. Here's another question which isn't so earth-shattering, but there are some amongst us, some tree huggers and all, and environmentalists who I think this will resonate with. We find information and developments hard to find. How about as-built drawings being filed digitally, especially at NEPA and municipal councils? Storing and finding paper drawings is definitely unwieldy, not to mention entirely unfriendly to the environment. We're all, of course, aware of the oodles and oodles of papers that have to be filed in triplicate and all kinds of clits, and quite often hard to recover or to retrieve years after. Is there some general trend, or that should we be either asking for or expecting, where we'll use digitalization to solve or reduce this strain?
There is a delicate copyright issue where that is involved. The plans which are prepared by professionals, engineers and architects and land surveyors, are copyright protected to those who prepared them and the developer on whose behalf they were prepared. It would technically be a breach of the copyright to make them generally available without the permission of the copyright holder. So I don't think that there can be general access to them. You can, under the Access to Information Act, make a request for the approval documents and see what was approved. And you would have a general idea of what to expect, how many units, the type of units, setback distances, so on and so forth. But as to the specific plans, no, that would likely offend copyright.
Okay, well, we're going to wrap up now. I think we are running out of time, or have run out of time. There's one question I see here, though. It's coming again from Gilroy English, and it says, what about using professionals / architects, engineers associated with the development to monitor and hold them accountable if there are breaches? It's an interesting question, because I also received another question on WhatsApp from another attorney at law, John Graham, where he complains that the matter of practical completion is in many contracts nowadays left in the hands of the architect or the QS to make a pronouncement on, which has far-reaching legal implications. But these people are actually employed by the developer, and he wonders at the conflict of it. And he also opines that they do not even have the kind of close monitoring that, for instance, other professions like us lawyers have. So they might not feel utterly constrained to be on their best behavior when they make these pronouncements. And they are, after all, just dancing to their master's voice, according to them. Your comments on this area?
Well, Chris, the statute requires that the local authority which grants the building approval is to issue a completion certificate. And that must precede the practical completion certificate. So if there's a practical completion certificate from the architect or QS or engineer employed to the developer, and there is none from the approving agency, the one issued privately cannot stand on its own. That's a simple answer to that one. So the request has to be made to get it from the approving agency. And once they say, yes, the infrastructure has been created, the place has been built in accordance with plans, then the subsequent certificate from the engineer or architect can be issued.
Yes, that is most insightful. I think that should put some clarity on that matter. Sadly, we're out of time. This has been a very exhilarating session. And as always, the time is never usually enough to go into the depth of what all we have to say. I'm going to give both Zachary and LICEA 10 seconds to have their parting shots.
Okay, I'll go first.
Go
Just
ahead.
to say that, yes, again, until we look at everything holistically, we will continue to have the issues coming up. The enforcement, I think, is one of the biggest areas, and just to have transparency and education so that everyone can be on the same page as to what is required, so that you can then do what is required. And it's not about who you know or who you don't know as to why your approval may be granted or not.
Thank you. Zachary?
Yeah, man, and I still would like to reiterate the point that Mr. Morgan said. The regulator bodies, there should be enough technical team to be able to understand the engineer's profession or the architectural profession, so that they can grant approvals as according to what the Act requires.
Yes. Thank you very much, ladies and gentlemen. There are several other questions that have remained unanswered. I'm going to be speaking with the organizers to find out if we can actually capture and perhaps direct these questions to the panelists here, so that we could have responses to the several other persons who have put in questions and queries and comments. Suffice it to say, however, that a lot of them have overwhelmingly endorsed the quality of the presentation and the content of what the presenters have said. So thank you very much for a job well done. We're now going to move to another commercial break so we can earn our keep, at which point we will transition to a different part of our program. Thanks very much.
Be fully prepared this hurricane season. Let BCIC Homeowners Insurance protect your home against hurricanes, floods, heavy winds and other damage with up to 11 months to pay your premium. And you can save 15% when you bundle home and car insurance. Call or visit any of our 8 branches for a quote. For more information, visit bciconline.com. BCIC. Everything we do is for you.
DigiView Security Limited. Operating for almost 15 years, DigiView Security Limited is one of Jamaica's premier electronic security solutions providers. DigiView offers top-of-the-line solutions and services to protect your home and business in the ever-evolving electronic security industry. AI features: perimeter protection camera, human detection and line cross, license plate recognition, panoramic 180-degree camera, 360-degree camera, face recognition, intelligent search and playback functions. DigiView Security Limited. See what you've been missing.
The Guaranteed Purchase Program is an initiative of the NHT to bring more houses faster to contributors. Under this agreement, the NHT will purchase housing solutions from developers for resale to its contributors. The GPP offers win-win solutions for everyone: the developers, the NHT, and most importantly, the contributors.
Hi, I'm Tanika Lawrence, Fund Sales and Service Officer for JMMB Fund Managers. Today, I'm answering the most frequently asked questions about our JMMB Optimum Capital Real Estate Unit Trust Fund. This unit trust is great if you've always wanted to invest in real estate, but you want to start small. Similar to what the name suggests, this fund is primarily invested in real estate. You get exposure to real estate market through rental income of commercial and residential properties, as well as other types of real estate assets. Why invest in the Optimum Capital Fund? This fund is designed for investors who want exposure to real estate but may not have the money to buy properties or may not be ready for that type of commitment. This fund allows you to pool with other investors and benefit from real estate returns. Speak with your JMMB representative today about building out your financial goals with our Optimum Capital Fund. JMMB, your best interest at heart.
The Jamaica Property Company has conceptualized, constructed, and managed iconic yet highly functional buildings since 1966. A range of clients include residential, commercial, and diplomatic operations across Kingston and St. Andrew, shaping the skyline by pioneering high-rises from downtown to New Kingston to Manor Park. The standard of property management is Jamaica Property Company.
So we're back. We now transition to a presentation by Mr. Ian Bennett, who is the Design and Engineering Manager at the National Water Commission. And his presentation will speak to water and sewage services, their availability for new developments. Mr. Bennett is a mechanical engineer with over 29 years experience in the public sector, working with the NWC. He has a Master's of Science degree in Mechanical Engineering from the University of Saskatchewan, Canada, and a Bachelor of Science BSc degree in Mechanical Engineering from the University of the West Indies, St. Augustine, Trinidad. He specializes in water and sewage engineering designs, and with focus on system design and optimization using hydraulic modeling. He has personally completed over 62 successful designs, and he manages a portfolio of over 340 design projects, along with rationalizing and modernizing the development process of the NWC as manager, engineering and design. Mr. Bennett, I now turn over to you to make your presentation. We are keeping the same format. After your presentation, I will introduce the panelists and we will have a lively discussion thereafter. So you have the floor.
Thank you, Mr. Honeywell. You all can hear me quite clearly?
Yes.
Okay, excellent. I'll just start the presentation. Thank you for this privilege of sharing some information with this wonderful group of people. And I hope that after this presentation, we'll be just a little bit closer to being able to, facilitate developments in our country. So I'll just start the presentation right away. Okay. Okay, excellent. Okay, so we want to look at water and sewage subdivision applications with regard to the National Water Commission. The Water Commission, we get so many questions and answers and solutions and concerns from many different people in many different quarters. So we want to just define a few things. What is the NWC's basic role in the approval process? Our basic role is premier potable water providers, as well as we provide primary sewage conveyance and disposal services. That is primarily what we do as in the development process. What else do we do? When you look at the NWC's development guide, we provide comments to the various organizations, developers, and different entities about the availability of this potable water service, as well as the availability of sewage services. Strictly speaking, at this time, the NWC is not a regulator as it used to be. And the NWC delivers the services that it endorses. If we say to you, we are going to deliver so much gallons to your particular development, it is incumbent upon us to ensure that all is delivered that particular volume of water that you require. NWC's requirements. Now, our requirements are not very onerous. We have some standard protocols and procedures, drawings, engineering reports, and so on that we require from developers who need to make an application to the National Water Commission. So what we find that makes the whole process a lot easier is if they're high quality submissions. It really does help to make that entire process easier, because we do have to actually assess what it is that you do and is it technically feasible as far as we're concerned. Or your site plans must be prepared by a commissioned land surveyor, and your engineering reports must be stamped and signed by the registered engineer in the respective discipline. We actually do read these reports. We take the information there very, very seriously, and we do go through the plans to ensure that there is technical efficacy in what is submitted. We also require suitable location maps and drawings. This is very essential to speed up the process, because sometimes if we don't know where a particular development is, specifically that property, then it makes the provision of our services much more difficult. NWC also requires that you give us what it is that you intend to use in terms of water and sewage services from the National Water Commission. So you might say, okay, we want to cut a particular plot of land in two, but when we look at the lot sizes, each lot is 5 acres. Now, you need to give us some more information about that 5 acres. It can't just be that you're going to put, we can't assume that you're going to put one house on that particular development, okay? And you must just simply submit your checklist to us. Provide suitable contact information so that we can contact you. Give us the name of the responsible officer, email your civic address and your phone number. Now, we have some issues with developments in general, and we want to look at them. Now, these are some of the issues that we wrestle with developments and developers from time to time. The issue of service lots. When it comes to service lots, the NWC says that we won't take over service lots until 60% occupancy has been achieved. Reason for this? There's the risk of water becoming old in the pipelines. And if the water becomes old because it's just sitting there for 2 or 3 years, then there are water quality issues once somebody finally decides to connect. We also have poor movement of sewage through the pipes. If we don't have sufficient number of persons living in the development, then we're going to have issues with the sewage being able to move through the pipelines. And there's also the issue of security of infrastructure. If there's nobody living in there, a handful of people living in there, we begin to find that the infrastructure is removed through theft and other matters. Just some issues. Some other issues that we have with developers very quickly. Bulk meters versus meter banks. There's a typical picture of your meter bank that only has a few of them in there. Now, there are some things that we want, that we generally say to developers. The NWC does not guarantee pressures to deliver water beyond the 2nd level. Okay, so if you have the ground, the first and the second floor, that's where we tend to say, okay, when you hit a second floor, you need to put in some additional infrastructure to guarantee supply to those levels. That's where we say, okay, tanks and pumps are required to deliver services to the ground first, second, third, fourth, and beyond. Okay, if that is not practical, then we suggest that a bulk meter be installed, which is a single meter, and then the organization manages the infrastructure internally. Okay. Looking at the issue of bulk meter versus meter banks again, there are legal implications for the NWC when it comes to water meters. Anything that comes before the water meters is technically the NWC's responsibility. So if it is that you have pumps and tanks and other infrastructure which comes before our meters, then it would be incumbent upon us to take over that infrastructure. If the NWC says we're not taking over that infrastructure, then we will not certainly want to put our meters after that infrastructure. Now, when it comes to detailed designs, very often when we get submissions from developers, they simply show a pipeline as a line, a simple line with nothing much on it. That's not good enough for us, because when we finally decide to do our inspections, then we have issues with wrong material, wrong type fittings, fittings which are not acceptable to the NWC. We often request that these detailed design drawings be submitted to the NWC before construction commences. That's very, very important, so that it doesn't cause any difficulties with the developer, with his timetable and with his implementation schedule. When it comes to detailed designs again, the NWC must agree with the material and construction techniques employed by the developer if we're going to take it over. It avoids delays during construction as the NWC inspects the infrastructure, and it facilitates smooth testing and takeover of the infrastructure, okay? When it comes to detailed designs, it avoids negative impacts on the NWC's operations and maintenance. So you might decide to put in a particular fitting or particular type of infrastructure, a particular pump. And when we finally decide to take it over, we have found in the past that our experience teaches us that that particular piece of equipment is not suitable for the NWC's maintenance and operations. So we do ask that you make those adjustments. All right. Now, the issue of impact fees. Oh boy, this one is a very interesting one. Impact fees are developers' contribution to the partial provision of the required infrastructure. So when the NWC goes through and we upgrade the Constant Spring treatment plant, and we do all of that infrastructure for several billion Jamaican dollars, we try to recover 30% of that cost. We're saying 70% will be recovered in revenues, but that shortfall that revenues doesn't cover, that 30%, we attempt to get that back from developers who will be directly impacted and benefit from that infrastructure improvement. And then that cost is now proportionally assigned to the developers by simply saying, if we apply an improvement of 10 million gallons to an area, and you want 1 million gallons out of it, then you pay 1/10 of that cost, okay? These fees are payable before connection of the development, okay? Now, some ways we intend to improve the development process. We want to update our development manual to put in some of the more recent technologies which have been introduced, especially when it comes to wastewater and so on. We want to get this manual out also into the public's eye so that it would be a proper guide to developers where it's easily accessible. It was on our website. I'm not sure it's there at this time, but we want to get the upgraded version done so that it can be published to guide developers. Next improvement factor, we want to interface with the Amanda system more efficiently. That way we wouldn't have to be fielding all these phone calls from developers to find out what is going on with their particular application. What we would simply do is we would simply upload our correspondence, our communication to Amanda, and then developers would simply talk to Amanda to find out what's going on. What we do to alleviate that problem is once we get an electronic contact for the developer, such as an email address, then we email those letters out so that they can get immediate access to it. some development trends so that we can see what is going on. Over the last, we took some data from our databases from 2006 until 2021. When you look at the number of lots, when you look at the development application and the number of lots we have received, it amounts to between 20,000 and 30,000 lots every year. What we have actually endorsed out of that as the NWC is about between 10 and 20,000 lots out of those development applications. What does that mean in terms of development applications that we receive? Over the years, we have been seeing a slight decline in the average number of development applications coming to us. It's now averaging about 800 per year. And what we have actually been endorsing is about 400 of those. So we have been actually giving our approvals to about half of what we receive. You might ask, what happens to the other half? Well, basically we say no, we don't have the capacity to provide you with the service that you request, okay? What does it mean in terms of the volume of water that we have been approving? Now, when we look at the applications say that we have been receiving between 6 million to 8 million imperial gallons per day as the average receipt of applications per year. Forgive me for my old units, okay? And what we have been actually endorsing is between 3 million to 5 million per year. Now, I want to show you a little map of what we have been approving in terms of developments in Jamaica. The green basically is saying, yes, we have approved it. The red is saying, basically, we have not approved it. Now, if you notice, there is a concentration of greens in Kingston and St. Andrew, St. Catherine. There's also some greens along the north coast. We're also seeing a spread of greens along the west coast, Montego Bay, cluster in Montego Bay. Going right around, you see we have been going around to Negril, Savlamar. But then there's a huge red cluster in Manchester, okay? Which means we have been receiving a tremendous number of applications in Mandeville, Christiana, Spalding, South Manchester, and so on, those areas. So far, we have been initiating some projects to improve the water supply in that area, and we need to address that situation. So what is incumbent upon us as the Water Commission? What we have to do is to ensure that all of those green areas that you're seeing there, that we are able to keep up with the requirement of water and sewage services for those particular areas. For the reds, what is incumbent upon us as the National Water Commission? We have to ensure that we find methods and ways where we can actually put sufficient water supply and sewage services as is required in those particular areas. It's not a tall order. If you notice the St. Thomas section, right now there's not much approvals going on in St. Thomas, but now we have been putting in water supply infrastructure there. We've been doing some improvements to the sewage infrastructure there. So we're expecting that applications will improve in that particular area. Again, if you notice in the Portland area, there's a little cluster in the north section of, northeast section of Portland. Not a lot. We expect that to improve soon with the roadworks and the pipe works going on in that area. So we have been looking at this whole, the whole map of Jamaica in a holistic way, where we're saying, okay, what is it that we can do in terms of a master plan? How can we go forward in terms of a master plan to improve the water supply network in the areas that are requiring water supply? And then we tend to use the development applications as the drivers. Where are we getting the applications? Where do we see as the priority areas now? How do we go forward in getting these areas, water supply and sewage services improved as the need arises? How do we look at even the overall plans in terms of what the government is doing, what is happening? How do we move forward in improving the water supplies? We're actively pursuing those options. We have our parish plans being created now and updated. We have the different projects being put forward. We have the different sections being put together and the different portfolio departments who are looking at all these particular areas. So we really want to begin to see how it is that we can improve those red dots and turn them into green dots. As you can see, the reds are quite extensive throughout several places. There's some places which we just have no water supply at this time, especially in the interior of St. Ann and interior of the country. Some places, there's just nothing there now. How do we make improvements, or how do we introduce services into those areas? Those are some of the questions that we have been asking, and we've been actually looking about design, seeking answers for those particular questions. All right, and that was my short presentation. Do you have any questions at this time? How can I help?
Yes, well, before we go to the questions, I want to thank you for the presentation, Mr. Bennett. We're going to do some commercials now, and after that, we will introduce our guest panelists who will come join you, and we'll field some questions at that point.
Sure.
Thank you.
Thank you.
The Jamaica Property Company has conceptualized, constructed, and managed iconic yet highly functional buildings since 1966. Our range of clients include residential, commercial, and diplomatic operations across Kingston and St. Andrew, shaping the skyline by pioneering high-rises from downtown to New Kingston to Manor Park. The standard of property management is Jamaica Property Company.
Every time you catch a glass of water, or you link a friend, look up things for your homework, carry out your job, enjoy an ice cold drink, or look forward to a delicious meal. Every time you chill out in front of the fan, remember, there's a network working behind the scenes just for you. That network is called JPS. We promise to keep on improving the way we serve you. JPS, powering what matters.
The Guaranteed Purchase Program is an initiative of the NHT to bring more houses faster to contributors. Under this agreement, the NHT will purchase housing solutions from developers for resale to its contributors. The GPP offers win-win solutions for everyone: the developers, the NHT, and most importantly, the contributors.
Be fully prepared this hurricane season. Let BCIC Homeowners Insurance protect your home against hurricanes, floods, heavy winds, and other damage with up to 11 months to pay your premium. And you can save 15% when you bundle home and car insurance. Call or visit any of our 8 branches for a quote. For more information, visit bciconline.com. BCIC. Everything we do is for you.
It appears that our commercials are at an end, and I therefore would like at this point in time to introduce our 2 panelists who will join Mr. Bennett for a very hopefully enlightening and lively discussion. The first of our guest panelists that I'd like to introduce is Mr. Christopher Burgess. Mr. Christopher Burgess, Dr. Burgess, is the Managing Director of CEAC Solutions and CEAC Outsourcing Company Limited. He has a PhD in Climate Studies, an MSc in Environmental Engineering from Imperial College of Science, Technology and Medicine, an MSc in Civil specializing in Coastal Engineering from Old Dominion University, and a BSc in Civil Engineering from the University of the West Indies, St. Augustine. In over his 80 years of experience as a consulting engineer, he has worked on roads, water, wastewater, drainage, infrastructure, palisados, projects, all stages of the implementation, from planning, implementation, permitting, etc. Dr. Burgess has worked for several government and private sector, multinational and other agencies across the Caribbean, and he has a virtual smorgasbord of projects that he can speak to. He's a registered professional engineer, a member of the Jamaican Institution of Engineers, and past board member of Spectrum Management Authority, Council of Persons with Disabilities, and the DQ, Donald Quarry High now school. I date myself with that. The other panelist is Mr. Richard Mullings. He's a director of M&M Limited. Mr. Mullings is the deputy managing director of M&M Limited. He's a civil and general engineer contractor with almost 30 years track record in delivering successful projects across Jamaica. He's also current first vice president of the Incorporated Master Builders Association of Jamaica. He holds a BSc in civil engineering from the University of the West Indies and an MBA from the University of Toronto, Rotman School of Business. He's a registered professional civil engineer with 15 years experience in the construction industry. I welcome you both, gentlemen, to our discussions this morning. You would have heard the very lively and informative presentation by Mr. Bennett, and I'd firstly like to canvass your opening comments, each of you in the order that I have presented you. Firstly, Dr. Burgess, your thoughts.
Thank you very much, Mr. Moderator, and good morning to my fellow panelists and others and attendees. Thank you, Ian, for a very informative presentation. It's fair to say that I had some insight, Mr. Moderator, into Ian's presentation. No ground-shattering information here, except one or two, for me, red flags that we need to address as a country. The first thing that I'd like to point out is that yes, NWC is our premier water and sewage service provider. There are others, they're private companies, and so NWC's success is going to be correlated to the speed at which development happens in some areas, and it's important that they succeed in what they're doing. We heard about the upgrading, or rather the updating of the developers manual, and we look forward to it. We remember when the developers manual came out in the 2000s, and it did solve a lot of issues which we had as engineers. It brought a lot of clarity to what expectations. We heard from you about the need for the Amanda system and how it might make your life easier to not have to field as many calls from some of us. And I don't know how you do it. You've maintained more or less one phone number over the years, and I can only imagine you have a lot of persons inquiring about their own applications. We shouldn't be operating this way, Mr. Moderator, in 2022 with phone calls. We really should have a more transparent system, the Amanda system. It's well placed in NEPA right now, but the intention, from what I understand, was that it could have been a government-wide system of information. You raised a point earlier, Moderator, about not submitting, well, the need rather to submit things in hard copy, and if we couldn't replace it with digital applications. And what Ian was alluding to with the Amanda system was the NWC could probably give us a better service as an entity if they had the Amanda system in place. And we support you wholeheartedly with that, Ian. And I really hope that the powers that we facilitate the rollout and expansion of the Amanda into NWC with urgency, great urgency, and not just in the NWC, but all the municipal corporations, so that Moderator wouldn't have to have these massive piles of paper that end up invariably on the balconies of a lot of these municipal corporations for insects to feast on. But we can leave that alone. We also unfortunately heard from Ian about the challenges across the island with the St. Anne, St. Mary, the difficult St. Catherine providing in Manchester, St. Elizabeth in providing water to all of those who apply. very important that these parishes and their water supply needs are addressed, because all of these parishes, including St. Catherine, have considerable housing demand, and it's important that, you know, the KSAC, for example, with 48,000 housing demand of 48,000, that NWC quickly resolve the issues with the outdated pipelines and the networks to give developers what they need to fuel this recovery process. Very good to hear as well, Ian, that you're putting in the pipes in the new St. Thomas Road. Hopefully we'll see in another 2-3 years where this parish will spring to life, to further life with a new road and water infrastructure, which has kind of held it back over the years. Overall, Mr. Moderator, I really thank Ian for his presentation, but I'd like to also hear some more from him about his impact fees and how he prorates them. He mentioned it, but we need to understand it better. This is one of the key concerns for some of the developers. I hope that summarized my first impression, but I have some questions for Ian as we, you know, continue
as we go further.
Yes.
Surely. I'm going to ask Mr. Mullings to speak, and then I'd be happy to turn over that first question that you have so cleverly concealed to Mr. Bennett about how he has come up upon the formula for those fees. So, Mr. Mullings.
Great. Good morning. I think we're still in the morning. Thanks to the JDA. Thank you, Moderator, Mr. Honeywell, Mr. Bennett, Dr. Burgess. First, I have to give kudos to the JDA for this webinar. It has been great, very informative. I think I see 400 plus participants, so I think the purpose is being met. I'm very happy to be part of the panelists for Mr. Bennett's presentation. As engineers, we tend to focus in on the technical elements of things, and in Ian's presentation, I think any engineer would have to support everything he's saying technically about how we make sure the end users, developers as the midway, the business and the end users, the residents, how we access the water supply, how we allow NWC to plan for providing the water and so on. But from a commercial point of view, if I step back from not just being an engineer and I talk about developers and commercial users, I think in recent times, my experience in trying to access development approvals in general, are we taking a view to transparency, ease of information, providing the information in such a way that the developers can plan to help the utilities, help the providers of the service. So for example, Mr. Bennett gave a very wonderful map there showing where they have issues providing water, approving water supply. So he could answer me, no, is that something that's generally available, provided at a source where the average developer, the small home developer trying to develop small properties, can they find that to understand where they should be trying to develop and where they should maybe hold back until water is available? That kind of, no, you can answer. Sorry.
Okay, what we tend to ask developers is don't wait until you are advanced in your planning before you contact the NWC. Simply give us a location map, tell us what it is that you think you would like to do and what kind of services you would want from us. And at that very, very preliminary stage, once you have the specific property that you're interested in, then we will give you an answer to say, hey, we can provide the service, we can't provide the service. If we're going to provide the service, then we think that these are the kind of upgrades that would be needed for your particular development. Or we might say, if there's a particular treatment plant that you're interested in, then these are the kind of upgrades that may be necessary. Or we'll simply tell you, no, at this time, for the next 5 years, we don't have that particular area on our radar. And we will answer you, trying to answer in short order, but we will give you an answer so that you know from the very, very early stage if you should make that investment on that property.
Right. Yeah. So you say Ian will put out, I know Ian means that, I know he'll put out the effort, but I know, like every other government agency, that they put all this poor work, all this massive work on Ian's desk, and honestly, he's a hero to do the amount of work he does, but it's unreasonable. And you go to the KSAC with the building inspector, it's the same thing. We have a massive work for unreasonably resourced departments. And we need as Dr. Burgess is saying, transparent technological solutions that push the information to the people who are using it. And that's a greater part of what I want to see happening. Transparency, ease of information. This will spur development in ways we don't understand. So that's my general comment.
And Mr. Mullings, if you look at the course of questions that have been posted on the Q&A, I think they resonate with that very concern of yours. They're asking the same question. How can they readily access that information for development purposes?
I look at the ages of the people. I'm the youngest in this group, I hope so. And as we come into the internet age, young people, young developers, they don't want to call everybody. They want to go on the internet, get it in a minute and get working. And that is how we speed up productivity. So that's my general thing. I don't want to hang up.
Okay, I want to just make a comment on that. What we are doing is we plan to make this GIS information here, because it's on a GIS platform. Some of the trends, we can't give you the specifics because some of the information is private, but the trends that are available, we can make some of those available to the public. So perhaps we're looking at how do we perhaps put it on our website? Can you zoom into certain specific areas to see what we have been approving and not been approving historically? That kind of information we are thinking of putting it out there to the public so that you can at least get a preliminary idea as to what the NWC has and has not traditionally endorsed over time.
I cannot see anybody objecting to that ever, that kind of information. I'm gonna add a layer that Dr. Burgess would love to. Why not tell us in some reasonable fashion, roughly what the recent impact fee per unit consumption is in relative areas? And let us know upfront. We can do our feasibilities early. We can say Kingston is expensive, but the sale prices are good, and we'll work it out. Or we can say, I don't know, Trelawney is a good value, sale prices are medium, but we can work it out in the wash. Or we can see where it won't work at all, and we translate that economically or commercially as we do what we do.
So we're back to that same question from Dr. Burgess. Is it the same question essentially you're asking, Doctor, about the formulation of the impact fee?
All right, so that was the second inning that I really wanted to do, but let's bring it up to the first. So Ian, there's this general feeling among developers that it's unclear what this impact fee is. Now I'm going to be generous with it because you put in the presentation as impact fee, but I have letters, for example, from somebody who you are very, very, very familiar with, that is, where it's referred to as impact, contribution. It was hyphenated with 3 words. It was I suppose it was a catch-all phrase. And it's unclear what it represents and how it is derived. There's this feeling that the NWC uses not the anxiety, but the good intentions of developers to pay for the enhancement of water supply systems in some of these areas. And a general sense that, for want of a better way of putting it, if it's not done, approvals might be delayed. What's the formula to approving, developments? What is it that you come and you have 100 houses, it's 50,000 for water supply services and 100,000 for sewage services? Is it purely regulated by OUR, or does NWC have a little magic formula where it's OUR plus an NWC factor? Tell us, because I think a lot of developers.
All right, well, first thing I want to say is every developer who gets an approval from us, the formula is on the back of the approval, how it's calculated. That's the first thing. So it is there, it's not hidden. And what we do is if the NWC goes into a particular area, and say we spend $10 million on a particular project, it's not 10 million, but say we spend $10 million on a particular project, and we deliver 10 million gallons of water into a particular community, okay? We are only recovering 30% of that 10 million from developers, because we have done some feasibility studies and calculations and recognize that revenue will take care of 70% of that expenditure, and the shortfall is 30%. So we're only recovering 30% of that $10 million. Now let's assume, Chris, you come in there and you want 1 million gallons out of that 10 million. Okay, we say to you, okay, your impact fee is the 10 million in terms of cost times 0.3 times your 1 million divided by the total water supply improvement of 10 million. So your cost would be $300,000. And that's how we calculate it right across the board.
I suspect your communications person, you probably need to sit down with you and come back to the JDA and its members and say, listen, we acknowledge that there's a gap in understanding here. You know, so don't feel stuck up. We're partners in development, want to help the Prime Minister achieve his housing objectives across the island and, you know, work hand in hand. But moderator, if you'd allow me another question. So I think I get the sense that
before you go on, Chris, before you go on, I just wanted to say that what we also intend to do in the Water Commission is we want to broadcast, or we have suggested that we broadcast our investment plan geographically island-wide. Okay, so if persons can begin to see what our geographic investment plan is, we have suggested this, it's in its infancy stages, then any stakeholder will be able to take up that plan in a particular area and begin to say that, oh, the NWC intends to make an investment of $1 million at that community. Therefore, there's liable to be an impact fee on me. Now, if we make the investment plan known, we also can tell you how much water supply we intend to be made available in that particular area. So if you know the cost and you know the water supply improvement, okay, then you can quickly calculate your own development fee and what it's likely to be.
And that actually, moderator, is a second point which a few developers have raised, is that, you know, the president of NWC has kind of told the public, don't go where we don't have water. Kind of little rough, because sometimes you see land that are ideal otherwise, it's just for the need of a mile of pipeline, which is not rocket science. If we knew as developers where the water was going to, where you were going to next in the capital plans, in a timely way. I've heard that 5 years, which I know is 20 years in some instances, but at least would be a starting point. You know, in next year we're going here, in 5 years time we're going there. Then developers can actually look at purchasing land in those areas and planning ahead. You know, which projects to put on the back burners and which ones to bring forward in their planning and approval process. I think your communication department could help a lot by communicating those plans to them. You have done a lot of hard work with those water supply improvement plans and others. And so get them into simple brochures and put them out there, communicate them. This year we're going to do this project, next year that project. It will help us to move in.
I agree with you, but we also know that the reverse is true. Because when we say we're going into a particular area, developers' timetable might not coincide with our timetable. So what we also need developers to do is to let us know their plans, because we may have to shift the plans to accommodate developers. Because if we're not going into a particular area and there's a shift for development in another area, is the NWC going to just stop and say, okay, you have to wait 15, 20 years? I think there needs to be a flow of information both ways so that we can understand where the development thrust is at this particular time. And it's a matter of, sometimes it's a matter of a cash flow on both sides. How can developers assist with their cash flow by not having delays? And how can developers assist NWC in terms of getting on board with the development in that particular area? So there needs to be we need to formulate some kind of a two-way flow of information so that we can both understand where the trends are, and then we adapt our projects and our outlook to match those trends.
I think both points are very well made and bear consideration. There's a question here from Courtney Laidlaw, which somewhat mirrors the discussion you're having. It reads, would the NWC be able to speak further to any of the projects regarding to the upgrade of water supply and delivery to the areas with the numerous red dots in Mr. Bennett's relevant presentation slide? Manchester and St. Elizabeth in particular, he says.
Well, there is a Manchester water supply development project in train right now, and we have done significant work on it. I don't have the details in front of me as I speak to you now, but that is in train. We have done, we spent about $300 million already on that particular project, and and it's just in the early phases to get water, improve the water supply from Pepper, improving the Pepper 1, 2, and 3 wells that in the Goshen area that delivers water to Mandeville are, let's just say Mandeville has grown beyond that capacity. We are now looking at other supplies. We are drilling an old Pepper well at the moment. We're looking at the cassava factory well and some other wells in the general area. And we have designed infrastructure to go all the way up to Kingsland, the Kingsland tank. And we have also looked at how do we get that water across Mandeville all the way to Mount Nelson and environs. We are also looking at how do we get water from the porous side up through some other wells and so on. So we are actively pursuing that particular project in tandem with developers in the area, because in the original days, we used to say just no to Mandeville because there just wasn't any capacity to deliver any improvement of supply. These days, we have opened the door and we are moving ahead with making some improvements in the water supply. Granted, it's in the early stages, but some significant developments are happening in Mandeville now, not just on a small scale, but on a larger scale. So we're trying to up the ante to provide the service required. Excuse me.
Chris?
Moderator, if you allow me some space to clean up the thoughts here, or to just to get a little longer.
You want me to come back to you? Well,
you want to go on to another question?
There's a Neil Mackenzie question here that says, more was spoken of water connections, but sewage connections, that was very brief. What additional requirements are needed with regards to new sewage connections for new developments? And if a development will happen over a long period of time, example, 10 years, what requirements and considerations will be given to the developers during that period?
Okay, in general, whenever we see an influx of development in a particular area, and there's a multiplicity of satellite sewage plants planned for a particular area, we tend to intervene and ask the developers, can we cooperate with you to build a central facility or some kind of central facility? And then based on the kind of response we get from developers, we try to move ahead with doing some kind of a central facility, so that we're doing this now for the Old Harbor area, where we're doing this also for some part of the Spanish Town area, where we can centralize and upgrade some of the facilities so that we can accommodate developments accordingly. So that's how we have been approaching it. Sewage services are a little tricky to do, because if developers are spread out over a large area or very large distances apart, then to provide sewage services can become uneconomical, simply because of the infrastructure to transport the sewage from point A to point B. So it depends on what the developers' interests are, and then we tend to cooperate with them to get them to come in, and we work with them accordingly.
Do you remember the question now, Chris? We're running out of time.
Yes, I do. So Ian, in 2011, the NWC prepared, I must say, very informative set of water supply improvement plans across the 14 parishes. For example, Kingston and St. Andrew, it was predicated that it needed $24 billion to improve the water supply in Kingston and St. Andrew. This, of course, would address the needs, the housing demand needs of about 48,000 homes. St. Andrew was $7 billion with a housing demand of 5,000. St. Mary, 10 billion.
Those were the parish plans, yeah?
Yeah, the parish plans. Manchester, 4 billion. So that's low, whatever, but another 5 billion. Where is the NWC with the rollout of these parish plans since 2011? Because obviously, the longer these plans are not implemented, it's the longer you're going to have to say, just as you said earlier, no to development. And we don't want to hear no. We want to hear yes. You know, as the Prime Minister said, we want to build 7,000 homes. So Where are we going? How far are we and how long are we going to send it? That's my
Oh boy, no, how far are we? I can attempt to answer. How long is a little difficult to answer because that is based on some other matters which are outside of my control. But what we're trying to do in recent time is not just develop parish plans, but try to look at the internal rate of return on those parish plans to see which plans make more economic sense at this time for us. And if we can get, if a particular set of parish plans make more economic sense to the NWC, then we would try to pursue those plans first as a priority. And then if we can get developers to come in to those areas and begin to support the NWC with its efforts, then certainly those plans will go forward in a much quicker way than if we have to attempt to use our existing revenues to fund massive capital projects. Of course, the NWC doesn't have the massive revenues to fund all our capital projects, which is unfortunate.
60 billion, 70 billion.
Well,
and the adding up, it was, well, it would work out about 90 billion now in today's money.
Well, it is more than just saying 90 billion, because we also have recurring projects which are not finished, which are significant figures, and all these things are recurring. So I believe if we can begin to have more, it has to be cooperative, where we can begin to see how the priorities are changing. Because what we said we wanted to do in 2011, in 2011, St. Catherine was the high point. But now if you look at the number of applications we're getting from St. Catherine, it's diminished, severely diminished.
This is because of the private utility companies and the roles that they're playing.
Well, for whatever the reason is, so if we
they're
had
filling the gap where NWC,
well, I'm just saying, if it is that we are not getting the applications from in terms of NWC, then certainly we can't just move ahead and put in all this infrastructure if there won't be any uptake on that infrastructure. So there has to be a cooperative effort. If it is that others have moved into a particular area, say Ocho Rios, for instance, and everybody is now having their own water supply in Ocho Rios, then certainly some of those upgrade, I'm just giving an area, okay?
And become less viable.
And because it's viable, because it's easy and it's all gravity, there's no pumping or much pumping that's required. And then you start to get a lot of private development companies, water supply companies going into Ocho Rios, and certainly we will not be able to do. What's that, please?
You said cherry picking and picking the best customers.
Right. So the NWC doesn't quite get that privilege. So we have to understand where the priorities are and then where to place our funds.
Gentlemen, sadly, we're going to have to wrap things up a little. But Mr. Bennett, because I have you here and because I still have a mother and she insists that I have to ask this question. she is a bit of an amateur environmentalist, and she's always discomforted when she hears that the major dams in Kingston, Mona and Hermitage, are silted up. And she asked, what in the near or the long future do we have as plans to augment our storage facilities?
All right, now that leads me to a very interesting answer. Many are saying, why not build 100 million gallons over in the Flatbridge area? A 100 million gallon storage capacity reservoir in Flatbridge over that side is only a week's worth of storage. It's not much. It's really not much compared to the investment that we would have to make to build such a facility. But what we don't understand, we did a recent isotopic study of the Kingston and St. Andrew area, and we recognize that we're actually sitting and living on the largest feasible reservoir right now, which is the basin that we live on. What we found in that study was that the water that hits the mountains of Kingston and St. Andrew are about the same age as the water that hits the sea. I'm talking runoff water now, okay? So the water doesn't spend enough time in the ground. It simply falls on the hill and it runs off to the sea. So we're losing a great opportunity of putting that water in the basin that we live on. And that's because we have been concreting the whole place. A lot of impermeable surfaces have been going up. We have been deforesting a lot of areas. So instead of the water getting a chance, the vegetation isn't holding the runoff water and giving it a chance to soak into the ground. So we have been finding that a lot of runoff water opportunity to recharge our aquifers is being lost. So I believe if we really serious about storage, especially in the Kingston and St. Andrew area, then we have to begin to look at how do we retain that runoff water and reintroduce it into our aquifers so that we can put that water into the best storage basin we have, which we live on at this time. So we have to look at finding a way, you know, perhaps doing it in zones. The upper zone where not many people live, how do we capture that water? The zone where people live, that we get a lot of runoff, how do we capture that water? Do we continue to let developers build impermeable surfaces everywhere? Shouldn't we introduce some kind of minimum permeable surface in developers to ensure that that water gets captured? And then we could look at a third zone. How do we deal with the runoff in the areas which are occupied and get close to the sea? A slightly different view would have to be taken in those areas. And that's not just an NWC plan. That would have to be a larger plan looking at a lot of areas with a lot of engineering disciplines to examine how that particular concept could work and how it would be applied. And if we begin to apply those concepts, looking at how we approve developments, how do we look at the permeable surfaces that we have? Should there be a minimum permeable surface so that we can store that water, so that it can stay in the aquifer that we live on, in the storage basin that we live on, so that, and then if we begin to clean up the aquifer, begin to sewer the basin that we live on right now, take the pits out so that we're not introducing raw sewage into that aquifer, then perhaps we might be able to improve over time or storage capacity in the basin that we live on. Okay, I hope that helped to answer your question a little bit.
I'm sure my mother is a lot more educated on the subject. Mr. Mullins, I'm going to give you the privilege of the parting shot. Dr. Burgess has had quite a bit of the play, so you get to see us off.
Unfortunately, I think I am going to come off as a, they call it, repeating, as if I am repeating myself.
But, which we don't actually condone in this particular program. but if you want to defer your closing to one of the other gentlemen, fine.
No, I just would say, if you're talking about development, growth, we call it cost of development, so that we can deliver things to what the Prime Minister has been trying to do, lower income housing, which is obviously a major gap in the commercial system. Then it comes down to efficiency of approvals is a big part of that. The efficiency of the multiple agency stakeholders to allow commerce to flow. Water Commission is just one of them, but we keep talking over and over about the Amanda system, and the whole concept is building centralized information that allows easy movement of information. If we can talk about this forever, but if someday we don't bell this cat, we're wasting time that we can never get back. So that's my simple point.
Duly noted. Gentlemen, there are some questions on the Q&A, which I invite you, particularly you, Mr. Bennett, if you can, while you're sitting in afterwards, hit a few of those and answer them, because some of them are quite interesting and thought-provoking. I'm going to thank you, gentlemen, all for a very lively, a very insightful presentation. The panelists have certainly created a different perspective and deepened an understanding of the presentation of Mr. Bennett. And I think that redounds to the benefit of all our listeners. Thank you very much. We're going to tell you goodbye now. And we're going to again cut to the much needed commercial break. Thank you very much, gentlemen.
Thank you.
The Jamaica Property Company has conceptualized, constructed, and managed iconic yet highly functional buildings since 1966. A range of clients include residential, commercial, and diplomatic operations across Kingston and St. Andrew. shaping the skyline by pioneering high-rises from downtown to New Kingston to Manor Park. The standard of property management is Jamaica Property Company.
Be fully prepared this hurricane season. Let BCIC Homeowners Insurance protect your home against hurricanes, floods, heavy winds and other damage with up to 11 months to pay your premium. And you can save 15% when you bundle home and car insurance. Call or visit any of our 8 branches for a quote. For more information, visit bciconline.com. BCIC. Everything we do is for you.
Hi, I'm Tanika Lawrence, Fund Sales and Service Officer for JMMB Fund Managers. Today, I'm answering the most frequently asked questions about our JMMB Optimum Capital Real Estate Unit Trust Fund. This unit trust is great if you've always wanted to invest in real estate, but you want to start small. Similar to what the name suggests, this fund is primarily invested in real estate. You get exposure to real estate market through rental income of commercial and residential properties, as well as other types of real estate assets. Why invest in the Optimum Capital Fund? This fund is designed for investors who want exposure to real estate but may not have the money to buy properties or may not be ready for that type of commitment. This fund allows you to pool with other investors and benefit from real estate returns. Speak with your JMMB representative today about building out your financial goals with our Optimum Capital Fund. JMMB, your best interest at heart.
The Guaranteed Purchase Program is an initiative of the NHT to bring more houses faster to contributors. Under this agreement, the NHT will purchase housing solutions from developers for resale to its contributors. The GPP offers win-win solutions for everyone: the developers, the NHT, and most importantly, the contributors.
DigiView Security Limited. Operating for almost 15 years, DigiView Security Limited is one of Jamaica's premier electronic security solutions providers. DigiView offers top-of-the-line solutions and services to protect your home and business in the ever-evolving electronic security industry. AI features: perimeter protection camera, human detection and line cross, license plate recognition, panoramic 180-degree camera, 360-degree camera, face recognition, intelligent search and playback functions. DigiView Security Limited. See what you've been missing.
Ladies and gentlemen, before we get to our next set of presentations, I want to pause to acknowledge the contribution of our sponsors, without whom this event would simply not be possible. You would have seen a lot of their ads so far, and you've seen their logos emblazoned across the screen. We have platinum sponsors in British Caribbean Insurance Company, Gore Developments Limited, Hardware and Lumber Limited, and Jamaica Property Company. We have gold sponsors in DigiViews Limited, Gian Group of Companies, Jamaica Money Market Brokers, and the Jamaica Public Service, as also the National Housing Trust. And we have silver sponsors in Caribbean Cement Company, Jamaica JMB Mortgage Indemnity Insurance, JN Bank, West Indies Home Contractors Limited, and bronze sponsors in Coldwell Bankers, Jamaica Realty, as also Millennium Properties. We acknowledge and we thank them for their support of this event. We have next two presentations which will be made in in tandem, they're correlated, one by Mr. Richard Case, who is the Director of Engineering Services in the JPS. And he will be speaking to smart homes and the future of renewables in Jamaica. Following on from his presentation will be one relating to the legal requirements before installation of solar PVC systems in new developments. And that one will be done by Ms. KADENE Campbell of the ministry. I will introduce Mr. Case now, and Ms. Campbell as she is prepared to do hers. And then after, we will have a Q&A session. So Mr. Rick Case, as he's called, has over 32 years in the electric utility industry and is currently Director of Engineering Services at the Jamaica Public Service Company Limited. He's a registered professional engineer, project management professional, and a technical consultant to various officers within the company, and works as Director of System Restoration on the Central Emergency Operations Center, CEAC, for disaster management and grid restoration. He holds a Bachelor of Engineering in Electrical Power Systems, first class, from the University of Technology, a Master of Science in Computer-Based Management Information Systems honors from the University of the West Indies, an Executive Masters of Science degree in the Management of Sporting Organizations, a bit of a curveball, MIMOS as it is called, from the International Olympic Committee. He has professional certificates in Modern Energy Management Systems from Georgia Tech, and smart grid modeling and control for island utilities from the University of Hawaii, Manoa. I'd like to ask you now, Mr. Case, to make the case for smart homes and the future of renewables in Jamaica.
Yes, thank you, Mr. Honeywell, for those kind words. And thank you for inviting JPS to participate in a forum like this. Typically, you don't mix electricity with water. You kind of want to put an installation somewhere between it. Following on Mr. Bennett, I was just nodding my head when he was speaking. So many similarities between what the development with water systems and electric systems, power systems in Jamaica. JPS is passionate about Jamaica's development. We're passionate about the future of energy in Jamaica. And we're also passionate about collaboration. We're very excited about renewable energy and the prospects that it can bring for Jamaica itself, and not just for the power system, but also for the environment itself. So I will be speaking about smart homes and the future of renewables in Jamaica. However, I'm going to speak about the renewables first and the smart homes after. I mean, they're actually two separate topics, but there are use cases where both interact and can actually work as a common solution for the future of energy in Jamaica. So I really would like to thank you and thank the JDA for this cooperation opportunity. I trust everybody is seeing my screen. So we do have a roadmap. The government of Jamaica in 2009 created the National Energy Policy. And this National Energy Policy outlines some broad, audacious goals for the country itself. Some of which the Prime Minister typically speaks about most times when he's speaking in public. One of the objectives really is to reduce the dependence on oil, and that by itself would reduce the pressure on the foreign exchange. As you know, we import oil and we have to use US dollars to buy that. Also, we want to create green and clean technologies and have a diversified energy base that builds resilience into our system itself. Of course, the environment is key in all of this. So we want to reduce our carbon footprint, increase our energy efficiency, and there were some goals that were set in this policy, which required that by 2030, 20% of the country's energy mix should be from renewable energy. And an informal target was set to increase that to 30% by 2030. However, the Prime Minister in 2018, I believe it was, thought that the 30% wasn't ambitious enough, and he proposed to increase that target to 50% by the year 2030. And we are now in 2022, and so we're talking about 8 years' time to aggressively make several investments in renewable energy that's going to move us from where we are now to 50% of the energy mix. There's a key point that I'm going to stress in the presentation just for the audience to understand what does that mean for Jamaica and what does it mean for the grid itself, right? So this slide here shows basically what the country of Jamaica, the gray circle shows where our concentration of load, or what we call our load centers, and the black lines is our backbone system, the 138 kV system, and the sort of grayish, greenish color looking lines are our 69 kV, that's our bulk transmission system. And the icons here just show where the various renewable energy sources are. Of course, you'd see some amount of HFO remaining on the grid, LNG in the mix. We still have some amount of automotive diesel, and as well as renewables that have taken prominence in recently. And of course, based on the Prime Minister's plan, you would see much more renewables being introduced into the grid. So Jamaica's context today, just looking on where we are, we have an installed capacity of 1,041 megawatts in Jamaica. And this is a combination of JPS-owned and private power-owned generators, which supply the demand. We have a typical peak day of 580 megawatts, and our lowest peak day, which typically is like on a public holiday, is somewhere around 400 megawatts. And I have the percentages broken down for solar and wind, which are what we call VRE, or variable renewable energy sources. Variable meaning that the supply is intermittent as it is available. So if you want to look on it in terms of where we are now from a capacity perspective, wind on the island, which has a total of 101 megawatts now, at 2 sites is roughly just under 10% of our installed capacity. Solar, which has a total of 57 megawatts connected to the main grid at two sites, is now 5.5%. On any given day, if we have very good wind and if these things are operating on the full capacity, then you can have a situation where from a capacity perspective, let us look on the 580 case, you could have about 17.5% of your capacity of your demand being met by wind or sun, right? Or the total combined VRE on a perfect day from a capacity perspective could be 27% of your peak demand. Hydro is mentioned there, and the total renewables is also mentioned there. We have, just for information, in terms of licensed, and I'm underlining licensed, rooftop solar, or what we call our net billing customers, that's roughly about 12 megawatts now. And we have installed a hybrid energy storage system, which basically is a large battery connected to the grid, which absorbs excess renewable energy, and it supplies the grid when the energy from those renewable sources disappears. So it basically works to keep the grid stable. And you'll find that the more renewable energy that you put into the grid, because of its intermittency, you have to add more storage so that you can maintain that reliable supply. This is what the energy mix looks like by technology currently. And I'm using this slide just to distinguish two things in terms of energy and capacity, right? So even though on the previous slide, you saw where we had these capacities for variable renewable energy, 27.5% on a perfect situation, or 15.2% capacity of the 1041, or on a low peak day, as much as 40% being supplied by the supplying the low load. Energy, however, is measured differently because energy is really power over time, right? And what you find happening now is that if you look at the renewable energy supply, just about 12% of the energy, or what is in the energy mix, comes from renewable energy. So we're at 12% now, and the government wants us to increase to 50%, right? You can actually look at the distribution of the other sources, all right? And the breakout is on the left, where you can see what solar is contributing from energy, wind is 6%, hydro is 3%, right? So what this means, and this is the distinction, when you interpret the policy itself, where the policy is saying that you need 50% energy to meet to be a part of the energy mix, there's a critical thing that we need to understand, and this is called the capacity factor. And the capacity factor basically is just a measure of how much energy is produced by a plant compared to its maximum output. And that is measured like as a percentage. And generally, it's just dividing the total energy produced over a particular period by the amount that the plant would have run at full capacity during that time. So when you consider, for example, that the sun, typically you get on a good day, you get 7 hours of sunlight out of a 24-hour period. Or you look at the fact that you have intermittency in wind, the wind doesn't blow at a constant speed all the time. You cannot use the capacity to think that because this installed capacity is there and available, that the resource is available to give you that full maximum output at all times, right? So the energy is what you actually get over time, right? So therefore, what it means is that you have to install so much more capacity on your system to get the energy that you need, all right? So when you look, for example, now, this is an excerpt from the Ministry of Science, Energy and Technology from their integrated resource plan. So after the government sets the policy, then that policy now has to turn into a plan, which it's kind of the integrated resource plan, where you actually start to look at what those strategic goals are and how you're actually going to meet those goals. And then you take that now and you actually perform a study on the system. So what this is saying now is that if you look at the case here, if we're going to get to 50% of the energy on renewables by 2037, based on where we have actually pushed it to now, what that means is that our grid will need to add, from a capacity perspective, 1,130 megawatts of solar and an additional 120 megawatts of wind. And hydro would have to increase by about 36 megawatts in order to meet those ambitions, right? So we're talking about massive investments in technology at various points on the grid. Of course, we know that solar takes up a lot of real estate, so that will have to be something that is creatively done through the evaluation process that the ministry will do, right? Wind is not so intrusive, but in order to capture all of that wind, chances are there might have to be a use case for offshore wind. And then hydro in Jamaica, we have primarily run-of-river hydros. So it will require some serious engineering to basically capture and produce 36 megawatts of hydro. But having done all of that, you're injecting so much power into the grid, you're gonna have a day when everything is just perfect. You know, Murphy is right there outside the door, and you're gonna have perfect sunshine, perfect wind on that particular day. The grid has to be able to absorb all of that capacity, even if it's instantaneous, without interrupting supply to people. So what that means is that significant investments are going to have to be made in terms of storing the excess energy, and also in terms of reinforcing the transmission and distribution systems to absorb all of that energy, right? And distribute it reliably without burning the wires or creating havoc on the grid. So we're basically, very serious engineering has to be done, and it really requires a coordinated approach between ourselves, the ministry, and the regulator and various agencies in this development plan. From a net billing perspective, the net billing, and the speaker who is going to follow me will speak in more details about the net billing program. But basically, this is what the customers who have rooftop solar, which is the most common case, or business places who have rooftop solar or renewable energy integration, they would receive a net billing license from MSET, and JPS basically would commission these systems, and they would get paid for the energy that they sell to the grid, right? So currently up to July, we had 697 systems, and that we have additional systems that we put in place. We have total 661, and a total of 12 megawatts, just about 12 megawatts of the target that was set, 12.8 megawatts. So we're very close to that target, and what this is suggesting is that the ministry will now have to relook the cap. So a cap was put on the system in 2012 when the government started the program, and they set that cap of 2% of the system peak, which worked out to 12.8 megawatts. What I'm saying is that as of July, we were just about 12 megawatts. So we're very close to the point where the system would naturally come to a close unless there's a revision of the program. So with all of this renewable energy, it brings a lot of challenges and a lot of opportunities. Some of them I spoke of before. Some of the key challenges include the intermittency, variability, the increased cost for transmission upgrades, the increased cost for smart technology. So the grid was designed primarily for power flow from a generating source to the customers. Now you have bidirectional power flow, and all of these are the type of intermittencies and whatnot. So you need smarter technologies on the grid to allow you to respond. And then just maintaining reliability and stability, it's going to become a significant challenge to be ahead of Mother Nature in maintaining the grid. But several opportunities exist with that. So we definitely, the environment is the winner here. We have to try to meet our goals under the Paris Climate Agreement. Electricity conversion alone won't do it. Of course, EVs, and we have to convert the transportation sector as well. And that is really when we're gonna make the quick jump to meet our promises under the carbon initiative. Energy security, of course, is a big opportunity here in that we have a diversified power base. We don't need to wait on tankers bringing in LNG or oil to get our grid up and running. Energy storage, of course, is going to open a whole new opportunity for energy storage, not just from a grid perspective, but also from a business perspective. So maybe there's a future for companies to perform what we call ancillary services and become an energy storage provider to the grid. So several new lines of businesses will come from this. Demand side management, of course, which is where you start getting into the smart home now. And this is a segue into the smart home segment, where now the home itself can become a regulator, either a net absorber or a net producer to help with the stability of the grid. And of course, resilience, you can recover faster. And then, of course, with all of these new technologies, particularly behind the meter, there are several opportunities that will come from that. So the smart home, as I said, has a role to play in all of this. And the big question is there, what is a smart home? Several people have different perspectives on the smart home, but ideally, the smart home should be a net zero facility for both energy and water. And it should provide the homeowner with comfort, connectivity, and control in mind. And what we're seeing now is that persons want control in the palm of their hands. So they want to be able to have full control, not just monitoring, but control of their home from the palm of their hands, meaning through a mobile device. The diagram that we have here actually shows where the appliance world is now becoming connected to this ecosystem of the smart home, right? And a lot of them now are coming with what we call HomeKit compatibility, meaning that the devices themselves are ready to speak to an app or speak to what we call a home energy management system to be controlled, right? And that control, of course, can be gatewayed right back to the utility, where the utility itself, based on particular grid situations, can instruct the home to change its operating parameters. And that typically is what the smart home is. So it responds automatically if left alone to its environment, and typically would be a net zero for energy and water. So the key components of the smart home, of course, is the smart meter. And the smart meters, JPS is already rolling out smart meters, so that interface is actually there. And it basically is a two-way communication between the utility and the home itself. Messages can be sent to the home on the same channels, interaction with the home and with behind the meter equipment. So it's capable of doing all of that already, right? There are what we call connected smart appliances. So fridges, washers, dryers, lights, all of these other things now are able to connect to that network at the home. So thermostat plugs, you name it. You need to have a smart hub, and a smart hub basically is that interface that converts from the user, the physical, to the network. So for example, you might have smart homes having things like Alexa or Siri, where you can give commands, or you have a mobile app where you can actually give commands, or you have sensors that automatically pick up what's happening in the environment and send those controls to the various devices to change their operating. And of course, there's some form of renewable energy source on it. So typically you'd have solar panels connected to it. It could be wind, it could be solar, and there's some form of energy storage. And this could be batteries, or it could be the electric car itself. So the car, through a vehicle to grid connection or grid to vehicle connection, the car can actually become part of the energy storage in the home. And then when the home needs energy, the car can release that energy into the home to supply the home, right? And the most critical part is you need good, reliable, strong Wi-Fi mesh internet. So these dead spots that people have now in the home, that's not permitted in a smart home. You have to have a full, strong internet strength right throughout the whole home, covering all of your connected devices. So we're talking about gig speeds in the home. And then the brain of it now would be what we call the SHEMS, or it would be a smart home energy management system. And there should be a in-home display, and it should be enabled with a mobile app. So the customer should be able to look on a panel in their home and see what their home is doing. Every bedroom, every appliance, however they want to look on it, what the car is doing, how much energy is in the battery, what the solar system is producing, how much we're taking from JPS, how much we're selling to JPS, how much money am I making? And those are the type of things that the smart home energy management system would do. And the various functions I mentioned before, demand side response and energy storage. So I had a recent trip to Korea where we have visited this demo station, which is a smart home demo station, where all of these devices were HomeKit ready and can be controlled, monitored in an emulated app, right? So the double door fridge, the TV, the speaker system, everything was fully connected, including the toilet. In Korea, the toilets use energy, and all of those things are there. The temperature in the room, you name it. They also had a smart energy building, since we're in a developers forum, and I know that you build commercial buildings and whatnot. And we might get to the point, as the Prime Minister is saying, about high-rise, high-density buildings. They have smart energy building, or the office systems, where you can see the power consumed on each floor. You can see the average temperature on each floor, and you can actually drill down and look from an office by office basis how much energy is being used in the various offices. You can change the parameters and what they call optimize the power utilization in the building itself. So I just have a couple of slides left. Two, the challenges facing smart homes. One is just the higher cost, but there's an opportunity to reimagine and redesign homes, choice of materials, etc. Right? There is the opportunity to amortize the higher cost for over a longer period for that saving benefit. Apartments and townhome complexes, it's difficult to incorporate individual solar storage and EV charging. The physical and suitable rooftop space for solar PV, that's a problem. So typically you get your best output from your south-facing sun. A lot of persons believe that, once I go outside and I see sun, it means that I can harvest it and I can offset my JPS bill. It might not necessarily be the case. So you need physical and suitable rooftop space for the solar PV, so that when the first hurricane comes as well, it remains. So the interoperability and connectivity, there's generally a lack of technical standards because there's a lack of cooperation. A lot of these things are still new, and manufacturers are still trying to feel their way out. So the interoperability of some of these devices, it's not just plug and play. We're not there yet. There's a high reliance on internet connectivity and high-speed networks. That goes without saying. With all the Zoom meetings, we see where things break up, we have challenges. So there's going to be even a greater reliance on internet connectivity and higher speed networks, right? There's a cost to upgrade your systems, appliances, software, privacy and security. That goes without saying. Right now with everything connected, what really is private and what really is secure. So when I can understand your energy pattern, your energy usage, what intelligence does that give me about you? Is that an invasion of your privacy? Some of those things are going to be covered in the Data Protection Act, right? The lack of regulation and monitoring. So we believe that stronger regulations are needed, stronger policies are needed in Jamaica for managing how renewables are actually deployed. And I suspect the speaker who is going to follow might speak on some of these things. But we reckon that there is more, we have 12 megawatts roughly of licensed solar PV installations on the grid. And we reckon that there's more than 6 times that amount of unlicensed systems out there now. Unregulated systems, unlicensed systems, just creating havoc or just a risk, right? Some of those things need to be addressed. There's low public education and awareness, and therefore there's low demand. So the public does not know about smart homes, the benefits of smart homes, the concept of smart homes. What will it do for me, right? So there's a low demand for it. So developers are not incentivized to put these devices in homes or to make the home smart. And they'll do it as long as they can get away with it. But the public will one day demand it, or you're going to have converging technologies where you cannot avoid it. There's not enough service technicians. Who do you call for help? Is it the appliance or the network? Is it the electrical system or is it the telecommunication system? And then, of course, there's the big elephant in the room, and that is climate change and climate departure. So what are we asking our future homes to be? We know from JPS perspective, there's a strong correlation between our ambient temperature and the demand for energy. And if we continue to build homes that are ovens, right? Then what does that mean for energy demand in Jamaica? People want to be comfortable. Can the design of these homes be such that they allow for, you know, persons to be more comfortable as we get hotter, right? So climate departure, they said that Jamaica is going to get to climate departure, Kingston is going to get to climate departure by 2023. And this is one race that we don't want to win. And what that means in layman terms is that the hottest day we would have experienced would become our baseline. And every other year, we will not recover or get cooler than that hottest day on record. And most people remember where we're coming from in the sun, in the summer, for the last 2 or so summers. So if next year's summer is going to be the hottest time for us, we're never going to get back to a cooler time before that. That's what we call the climate departure, right? So we definitely don't want that. So we're challenged to as futurists look at this opportunity and fix it before the problem occurs. And then in conclusion, I believe the smart home is essential for Jamaica's sustainable future. The challenge, I believe, is to make it the norm and not the exception. A whole lot of lines of business. I can see the young people already thinking about how they're gonna monetize all of this, right? Create new businesses just from behind the home, behind the meter services, right? We already demonstrated that the smart home will be a node on the grid, on the larger grid, and participates in grid functions. And architects and developers need to define what I call sustainable structures to meet the real or the future needs for Jamaica in the context of what we have. And finally, financial institutions need to be more creative in providing solutions and incentives for smart home projects and also for smart home ownership. And here I'd want to stop and just to reiterate that JPS is committed to Jamaica's growth and prosperity. Thank you. Over to you, Mr. Honeywell.
Thank you very much, Mr. Case. That was a very futuristic and stimulating presentation. Before we break, instead of breaking, I'm going to ask that Ms. KADENE Campbell continue on and make her presentation in short order right behind you. So I'd like to do her introduction now, and after she has made her presentation, since they somewhat complement each other, we'll after that have the Q&A session with the panelists. So Ms. Campbell, if I may introduce you, Ms. Campbell is an attorney at law, and she's practicing law in Jamaica for about 10 years now. She is employed to the Ministry of Science, Energy, and Technology. She's a country girl, went to Alvernia High School, and then somehow continued at Portmore Community College. She obviously is a graduate of the Norman Manley Law School. She has been practicing both privately and publicly for nearly 10 years now, and she's currently employed, as I've said, in the public service in the Ministry of Technology, Science rather, Energy and Technology. She will be giving us a very workmanlike and technical dissertation on the legal requirements before, not during or after, before installations of solar PV systems in new developments. Ms. Campbell, could you please go ahead? You're mute, Ms. Campbell.
Thank you, Mr. Moderator.
I'm hearing you now, yes.
Great. So good afternoon, members of the panel and all viewers online and other platforms. The ministry was invited to speak on the legal requirements before installation of solar PV systems in new developments. So the presentation will briefly outline the governing framework for the electricity sector, the key consideration, and the legal requirements. Now, the legal and policy framework that governs the generation of electricity and the use of solar PV systems is a type of technology for the generation of electricity by individuals, as it is outlined in the law. Now, the Electricity Act of 2015 governs this type of arrangement. The net billing regulations of 2022, those have been gazetted recently in September 29. The OUR Act applies in terms of the regulation and monitoring, and the National Energy Policy 2009 have implications, and the JPS license 2016. So all these instruments have implications for the energy sector, and certainly in some respect to the net billing regime. But primarily this presentation will focus on the Electricity Act and the net billing regulations. Now, under the Electricity Act, a person who carries out any of the activities listed there, generation, transmission, distribution, supply, and dispatch, will require an electricity license issued from this ministry under the signature of the minister with responsibility for the electricity sector. Now, you will note on screen that in relation to transmission, distribution, supply, the single buyer, which is JPS, which is the only operator of the grid, has an exclusive license for those activities. Now, in relation to generation, that activity is more liberalized, and it provides the avenue through which solar PV panels can be commissioned to generate electricity for individual consumption. Now, the key terms in relation to this type of self-generation under the Electricity Act are a self-generator and net billing. Now, the self-generator is a person who generates electricity for that person's own exclusive use and shall include a person who has entered into a net billing or a wheeling arrangement. Now, the net billing arrangement, which is the type of arrangement contemplated by the installation of solar PV systems, is a mechanism whereby self-generators sell or otherwise is a mechanism whereby the self-generators sell or are otherwise credited with the value for excess power generated under a standard offer contract with the JPS, and this contract is approved by the Office of Utilities Regulation, and we would know that the OUR is the regulator for the electricity sector. Now, the Electricity Act stipulates that any person who engages in the generation, transmission, distribution, dispatch, and supply of electricity must have an electricity license in order to do any of those activities. And the application is to be made in the manner prescribed, and the form and manner prescribed are detailed in the electricity net billing regulations of 2022. Now, someone who is contemplating the generation of electricity for that person's own use and who would also have an opportunity to sell excess to JPS would need to be guided by these requirements for eligibility. So as I've mentioned before, this person would require an electricity license. And in order to get to the license, then this person would need to complete the application form. They'd have to be a customer of JPS because they are required to submit an invoice as an accompanying document with the application form. There is a requirement for the applicant to demonstrate proof of ownership of the property on which the generation facility would be installed, and or if the person doesn't own the property, they would be required to submit the permission of the owner. The application would need to be accompanied by a certified electrical line drawing for the generation system that is going to be installed. And I would advise that notice taken of the fact that the capacity amount for residential installation is up to 10 kilowatts, and for commercial entities is up to 100 kilowatts. And that will not be exceeded because, as the previous presenter had mentioned, these are limits that are set by the integrated resource plan, which looks at the system and determine the necessary decision in relation to its proper functioning. Now, having obtained the license, the applicant is required to enter into a standard offer contract, that is the name of the contract, with the JPS Co, and the terms of which are approved by the OUR. They will be required to thereafter to purchase and install the relevant equipment, and to note also that the Bureau of Standards certifies the standards for the equipment that is being used, and they are to obtain a certificate of compliance from a licensed electrical inspector indicating that the electrical works are according to specification because there are generation and other codes and guidelines that are required to be met in the installation. And you would appreciate that this is required for safety and proper operation of the grid and also other critical considerations. With all that in place, the JPS would then commission the system. The fees and charges involved so there is a non-refundable processing fee when the application for the license is submitted to the ministry. Where the application is approved, then a license fee is paid. There is a use of system charge that is paid to the JPS, and this is intended to compensate the JPS for the use by the applicant of its distribution system, and the applicant would necessarily be mindful of the cost to purchase the equipment and apparatus required, and there is the cost for installation and setup. Now, this is a repeat of what has gone on before. The obligations or other consideration of the self-generator would be to procure, install, and operate the electrical equipment or apparatus in accordance with the applicable standards. The self-generator is required to commence the net billing within 12 months of the granting of the license, and failure to do so may result in revocation, the standard offer contract with JPS being terminated, and JPS being released from any obligations to connect the self-generator system to the grid. Now, the self-generator should be mindful that the excess electricity that is sold to the JPS, they will be paid, or it will be otherwise credited to their account based on the terms of agreement with the JPS. And this is done on a monthly basis. The rate at which the amount generated and sold is the rate at which the dollar value is attached is approved by the OUR, and I believe that JPS does the calculation. The license that is issued for net billing and the standard offer contract, they are valid for 10 years and they run with each other. That is the end of the presentation on the legal requirements before establishing the PV system, solar PV systems. I thank you.
Thank you very much, Ms. Campbell, for that presentation. We're going to go straight to a commercial break, and afterwards we'll introduce our panelists and have a lively discussion on the two presentations and the way that they've inspired us as developers.
The Jamaica Property Company has conceptualized, constructed, and managed iconic yet highly functional buildings since 1966. A range of clients include residential, commercial, and diplomatic operations across Kingston and St. Andrew, shaping the skyline by pioneering high-rises from downtown to New Kingston to Manor Park. The standard of property management is Jamaica Property Company.
For almost 40 years, the GEON Group of companies have been developing plans, laying foundations, building hundreds of homes of distinction, creating exclusive and secure communities in which we live, play, and raise families. The Geon Group of companies, creating homes that people enjoy.
Every time you catch a glass of water, or you link a friend, look up things for your homework, carry out your job, enjoy an ice cold drink, or look forward to a delicious meal. Every time you chill out in front of the fan, remember, there's a network working behind the scenes just for you. It's called JPS. We promise to keep on improving the way we serve you. JPS, powering what matters.
Be fully prepared this hurricane season. Let BCIC Homeowners Insurance protect your home against hurricanes, floods, heavy winds, and other damage with up to 11 months to pay your premium. And you can save 15% when you bundle home and car insurance. Call or visit any of our 8 branches for a quote. For more information, visit bciconline.com. BCIC. Everything we do is for you.
And so, following up on those two very instructive presentations from Mr. Case and Ms. Campbell, I'd like to now introduce our panelists. Firstly, Mr. Richard May, and he's the Managing Director of ECOS Consulting Limited. I hope I have pronounced that properly. Mr. May is the Managing Director of ECOS, group of companies with extensive experience with designing management systems for sustainability in energy, environmental risk management, safety, emergency management, and other areas related to environmental sustainability and operational risk management. As a qualified and active leader in the auditing of standards, including EarthCheck, Crystal International, etc., Mr. May has worked through commercial and hospitality sectors across the Caribbean, and over the past 26 years has made significant inroads in his field. He's a holder of a MSc in Hospitality, Business Management, bachelor's degree in Chemical Engineering and Business Administration, as well as diplomas and postgraduate diplomas in areas covering a wide range of professional and subject matters related to the said environmental risk management, etc. He has completed a number of successful government and private sector projects in both Jamaica and the wider Caribbean, and indeed has extended his work footprint into Australia, the UK, and the US. We are delighted to have him on our panel. The second panelist for this, our closing section of our presentation today, is Mr. Jason Robinson, and he is the Managing Director of SolarBuzz. He's the CEO and co-founder of SolarBuzz Jamaica Limited. He has led SolarBuzz to become one of the leading EPC renewable energy companies in Jamaica. As Vice President of the Jamaica Renewable Energy Association, formerly Jamaica Solar Energy Association, he spent a lot of his time helping to shape energy policy for the entire island. Jason has also featured in Forbes as one of 6 renewable energy entrepreneurs lighting up Jamaica, pioneering the way towards energy freedom while doing no less than saving the planet. We welcome you both to this part of our presentation. You have heard the two presenters speak, and while I do not propose that this will simply be a Q&A on what they have presented, I'd certainly also want you to roam a little afield in terms of how their presentations would have inspired you to think of and to, from the context of developers, shape the way going forward. I'm going to ask you to have a few opening remarks, each of you, in the order that I presented you. First, Mr. May.
All right, thank you very much. And thanks to the JDA for having this very, very informative webinar. I found both presentations particularly interesting and inspiring, full of information. Mr. Case, in making his comments regarding renewable energy and the smart home, I found the information to be very much in line with where we need to be looking as a country, an island state where we're currently importing the bulk of the resource needed to generate our energy. To find ourselves in a position where we're self-reliant, self-sustainable where energy is concerned, does in fact require serious look at renewables and the likes. And his suggestion or indication of the value of the smart home, smart technology, the use of up and coming and available technologies to remove the risk of human error, to reduce the reliance on fossil fuels and the likes, is very much in line with where we as advisors, as energy experts would want to see a company in the position of the JPS, a utility entity, looking. And I was actually impressed that his focus and by extension the focus of the JPS is actually such that it is in line with the goals of the government, the Prime Minister, and the goals of companies like Ecos Consulting and Solar Buzz, and those of us who are committed to a sustainable future for the company where energy is concerned and otherwise, and actually a planet we can continue to live on. It is commendable, to say the very least, that the presentation covered all of these things. Important to note his identification of the fact that meeting our 2030 goals for renewable energy requires significant investment. Like anything else in life, if we're going to have significant investment, then there's going to be significant cost, meaning the end user will likely end up paying something to that. And it's one of the things that I'm going to actually ask him to look at or to expound on, is what is the kind of risk, or what's the kind of impact that the end user should expect or contemplate if and when the JPSCO moves into, or when the government moves into, this extended push to renewables. What is that going to look like on my light bill 5 years from now, 10 years from now? Balance that against how can I improve my use of or adopt use of renewables to help me, the average homeowner, offset these possible increases. And then thirdly, what happens when a number of homes, residences, or operations implement solar? I am trying not to be too confusing. What happens when a number of these entities implement solar and other such technologies for efficiency, and there are end users who have not gone that road? What happens to those persons? What's the impact to their light bills? I think, in a nutshell, with my admiration for the presentation, those are the three questions I have at this point. For the presentation by the OUR, it is, the information has been available for a while, and I thank the presenter for putting that out there, because it is also very necessary that we remind ourselves and the public at large that there is a regulated process for going solar. It's not a case of finding Mr. Jones's brother's cousin who knows how to put up some panels and wire the house and you're good to go. There is a process. We should be sticking to the letter of the law, because it is these regulations that help entities like the JPS to continue to provide and balance the utilities that we actually need. That's my 2 cents.
Thank you very much, Mr. May. Mr. Robinson, can we hear from you?
Sure. Can you hear me?
Yes, we can.
Great. Thank you, Mr. Honeywell. You've been doing a great job. Thank you, Ricardo and KADENE, for your presentation. Hello, Richard. Good to see you again. I'd like to thank the JDA as well for inviting me to be a panelist on this important topic. Before I make my points, I just want to say that the solar energy company that anyone hires will handle all the net billing process for you. Don't let the presentation by KADENE scare you off too much. We take on all of that headache for you, and we can discuss more of that later on. I think both presentations highlighted the need for a strong green building policies when it comes to encouraging developers to construct with renewables and energy efficiency in mind. They also highlighted the gap that can be filled by organizations like the Jamaica Developers Association, who can have a huge impact on the government's green building policy that needs to be in place going forward. For instance, homes and buildings need to have roofs built to accommodate solar panels. There needs to be piping in place to be able to run the wires from the solar array on the rooftops to the main electrical panels. And equipment rooms need to be in the plans to house equipment such as batteries and inverters. Also, electrical vehicle infrastructure has to be in a building policy, since the government is giving duty concessions encouraging the purchase of EVs. An example is electricals for EV chargers being put in place from initial construction so that apartment building tenants can install an EV charger easily at their parking spot if they choose to buy an electric vehicle. And Ricardo and I have a very informative YouTube video on the Solar Buzz YouTube channel if anyone is interested on this, seeing what Ricardo has to say, and very informative on EV policy in Jamaica and where it's going. Along with the net billing policy, where the property can sell back excess power to the grid, the government has to put in place green building codes for what I previously mentioned, so that Jamaica has the proper foundation to build where renewables and smart buildings are the norm going forward. So once a green building policy is in place, there will be less pressure on the JPS grid, less dependence on foreign fuel, and an enormous reduction in Jamaica's carbon footprint. So it's going to come down to convincing developers that building with these green measures are worth the investment, because yes, it will cost them a little more initially to build. So I hope that this panel will ease some concerns today that will encourage green building in the future, as Jamaica's future depends on it.
Thank you very much, Mr. Robbins. There are quite a few questions that have been asked on the Q&A. I am going to go through some of them. I wanted to know, Mr. Case, if based on the opening comments of the panelists, if you had any responses that you wanted to make at this point in time before going to the questions.
Certainly, I'd like to answer Richard's. Richard asked 3 questions, 3 good questions, which might cover some of the questions that might be in the chat. So his first question was, what is that cost of all of that investment going to look like? And who typically might bear the cost? Because significant investment it signals that there will be significant cost increases, right? So we take a very, very long-term look at these investments. And where the horizon was 2037, and we're actually looking to 2045. So we're doing simulations and studies up to even 2045 now. And several assumptions were made. But you're absolutely correct. Because of the high capital cost investment, you're gonna have a period of increases before you get to the point where you break the curve and then the costs start going down. So it's gonna be a while before you can turn off the fasten seatbelt sign and walk around freely in the cabinet. But I wouldn't be able to tell you in the cabin, sorry. I wouldn't be able to tell you what that cost is going to be right now because the government is going to go for the procurement. I'm not sure what the finalized energy mix will be. The government handles the procurement, all of it, and we would participate just like any other competitor in that procurement process, trying to win bids to add renewable energy to the grid, just like anybody else, right? So yes, typically you're gonna have most business models. If Jason decides to participate in the bid, his cost recovery would include recovering maybe the most of his capital in the first 15 years. And then in the last 10 years of his contract, that's gravy. So typically a lot of persons, their investment profile might follow that. You also ask about energy efficiency measures, right? Oh, just to kind of flip back to the first one. So if you're looking on the whole economy, the displacement of oil will cause some savings in the economy itself. But in terms of the price of energy, you may have some, as I say, initial increase in the price of energy until it goes down. But the savings on other things in the economy might just counter that, right? Energy efficiency measures, of course, that will have to be a campaign. Most of these devices now, the appliances being put in, some of the things Jason spoke about in terms of making the home greener, cooler, smarter, to have less reliance on forced or energy used supply for cooling air and things of that nature will redound to improve energy measures, sealed buildings, you're not losing cool air to the atmosphere and whatnot. And then you ask what happens when some persons do it and some persons don't. And this is where we're advocating for the ministry to actually be more vigilant in their monitoring, because as you rightly said, there's a safety concern and a safety element to it. Safety not just for our workers working on the power systems, but safety for the occupants in the homes. So Jason will tell you that not all persons are official registered companies like himself. You have persons now just doing solar installations, people trusting them to put panels on their roof and interfering with their investment, for want of a better word, right? And maybe even absorbing some risk that they need not take, right? So when you're talking about persons who do it and don't, the ministry has to be more vigilant with the program, have more oversight, more monitoring. The technology is there to make it visible, and you can actually see this production in real time from a grid level. It's possible even now. So I'm just putting those things out there that, we need not be cautious with the technology that is out there now to monitor and respond to what the grid is saying.
Chris, could I also add to that when Ricardo has mentioned, and he mentioned in his presentation, there's a lot of unregulated, unlicensed systems on the grid and people who are not licensed doing it. This is true, and I think there's one thing that that I think KADENE would need to speak to is that I have done many net billing licenses over the years, right? From 2014 coming forward, many. The net billing process application-wise has not been the easiest thing to handle, and which is why I had also mentioned it in the beginning that we take that on for our clients, because I'd never want to put my enemy through that, to be honest, right? It has gotten a little better of late. I will say Todd Johnson and his team have done a better job of communicating to get it to where it was, but it was at a virtual standstill about 6 months ago, and they're trying to revamp it now. But that process, with all the red tape that the Jamaica Renewable Energy Association has experienced and written to the minister about even recently, discourages a lot of people from applying. So the benefit of net billing is that when you sell to the grid, you get 30% payback on the energy you sell them you get 30% of the rate that you pay JPS. So it's not a tremendous amount. So for homeowners especially, it's not really usually feasible because it's going to cost you when you hire the people to do the drawings, do the application fees, the entire process that now you hire the GER, 1,500 US, close to 2,000 US possibly. So to go through all the red tape of the net billing, it has to be a commercial company normally that is closed on the weekends. It's going to get some sort of benefit to do it and pay those fees. I don't think that the way it is set up now is going to encourage a lot of solar companies. There's a lot of legit solar companies who are just not applying for net billing anymore because the process is too much to deal with. There's too much red tape. So I was hoping KADENE could speak on it and maybe let us know what can be done to alleviate that, make it more modern, more technologically accessible, etc. But I think that's part of the problem that when you see RICARDO say 6 times are more unregulated on the grid than regulated.
Yes. KADENE, would you care to respond?
So I cannot speak to the specifics, but I am aware that the ministry, led by the Energy Division, is looking into the processes surrounding the application for net billing licenses. We have gotten feedback from the Jamaica Renewable Energy Association in relation to the issues that they're having with the processes. And I can say that those are being addressed. And he indicated that there has been an improvement over the last 6 months. And I expect that it will only continue to improve so that there is more efficiency and access. Now, in relation to the unlicensed generators on the grid, now, if that information is with the ministry, we are looking at the Electricity Act. The review is currently before the Joint Select Committee, and the part of the consideration is looking into all the arrangements for electricity licenses that are currently in use. And we have had feedback based on the consultation and stakeholders' comments on the efficiencies or a lack thereof in relation to the legal framework, and those are being debated, and the conclusion of the Special Committee of Parliament will address these issues.
Thank you very much. There's a sense in which I'd like to maybe suggest that we reframe how we come to our deliberations on this point. A lot of what we're discussing here stems from the existing regulatory framework whereby JPS exists as, under their license, a monopoly to provide and distribute electrical services. And the extent to which these renewables are being done is almost as an adjunct to and a slight variation to what is essentially a dominant monopoly position that they hold. Now, if we use 2030 as an objective deadline that we should move from 12 to 30% in, and if we're reminded, as Mr. Case has told us, that next year things are going to get crazy when it comes to temperature and stuff, we realize that we're not talking about a business as usual scenario. Bearing in mind that the license, the JPS license, is perhaps, I think, up for renewal by about 2026 or 2027, would now not be a most opposite time for us as developers and as social engineers to perhaps think of what role we could play in, as the Prime Minister has encouraged us, lobbying to see that there are some kind of changes to that monopolistic structure. For instance, to allow for developers doing 20, 30, 100, 200 units, to be able to actually design and build those energy solutions in those buildings, and in that way amortize the cost to the persons who actually eventually purchase those homes, rather than us laboriously trying to go through this age-old system of individually yoking John Tom with his house on the hill with the entire sunk costs of doing the development. Isn't it maybe a way that we could think that at this juncture we could change things a bit?
Chris, that exists already. That exists
I
now.
think,
And
sorry,
there's a framework for that which exists already now. And JPS doesn't have a monopoly on the supply. And that's why the act was modified to allow for self-generation.
Yes, it's a distribution though I'm going after.
No, net billing is just one part of it. You know,
it's a distribution I'm going after though. So that developer would develop that 200 houses, and he would put a centralized solar system on the side of the hill, and they would either buy into some cooperative or he would be selling them the energy over time. So we're really talking about moving into a distribution, which would offend the present limitations.
Okay, understood.
Yeah.
But what's your comment on that? I mean, as I'm asking as from the developer's standpoint, and notice Mr. Dayton Wood has his hand up. I'm going to ask him to speak, but I'd certainly like to hear your comments on that. I imagine Mr. Case can't say much on this. It's really me taking a bite and a slice at what their established business model is. But perhaps going forward, the imperatives of what we face might cause us to look at things a little differently.
Yes, I think that definitely that's not allowed currently. You can only have one solar system feeding 1 meter currently. So yes, if things were to change and that could be an option, I think it could be a successful solution. I think for builders and developers currently, what they should focus on is building with solar energy already a part of the home, so that when someone goes to get a mortgage, they can include the solar costs in the mortgage and have that stretched over 20, 30 years. I think that's an easier, immediate solution for providing your development with low JPS bills and resilient backup power, which we need living in a hurricane zone like Jamaica. I think that, yes, that would be an initial way to go. Your option is an ideal solution. Yes, I mean, you know, I think that even speaks to an aspect of possibly wheeling that I know Ricardo may speak on later on, where you can have a centralized solar system that gives you credit to other locations around the island, which would be great for commercial entities, which they say is coming on track sooner, has been approved, but I don't think there is one in running as yet. So there are similar options. You know, I think developers need to build with solar as part, and renewable energy and smart home technology into the cost of the houses, so that when it's financed, it's stretched over 20, 30 years, and you're getting resilient backup power with no JPS bill or no energy bill.
Yes, thank you. Mr. Wood, would you like to come in at this point in time?
Yes, just to say thanks to our presenters and our panelists for excellent presentations. But the cost of, I know the law was recently amended. Remind me, what has happened about the import tax on solar equipment and batteries and so on? Where is that now? Because if I'm sure that we want to get to smart homes and so on. Bringing down those costs, that's one of the first thing that needs to happen, is that tax needs to come down. And if we want to build 70,000 homes and to really address low-income homeowners, that is where a smart home, certainly solar power, certainly water recycling and harvesting needs to take place. And that equipment needs to come in at a very low cost, so that it can be as you say, amortized over 30 years and so on. And the low-cost homeowner not facing these large bills. Where are we in that type of regulation to bring those costs down now?
Well, there's no GCT on solar equipment coming into the island, and the GCT on lithium batteries was recently removed by the government. So solar equipment is coming in duty and GCT free, and then I think Richard can more speak to the energy efficiency equipment that comes in. I think has some tax breaks as well. So it does come in without being taxed.
Yes, Richard, you're up.
Yes, I was gonna, two things. Both yourself and Jason preempted one of my issues, or one of my comments regarding installation of solar at the development or the design stage of the home, because as Jason said, if you go to the mortgage agency with the solar already included, you amortize the cost of that system, well, over 20, 30 years of a mortgage, and your cost of energy at that point would be almost negligible compared to what you'd be paying to a JPSCO or any other utility. Now, on the issue, Dayton, you just mentioned, currently, or the situation now of building 70,000 homes on a low income basis, and Jason can confirm, you wouldn't be putting maybe more than 2 kilowatts of solar on each of those houses. You can accommodate that within $1 million Jamaican dollars relatively easily today. So I think there may need to be a discussion between the developers and us solar providers about the true cost of what it takes to put solar on homes, because 2 kilowatt system on a mid-income, low-income house will not, the impact on your mortgage is going to be almost invisible. The cost to the developer is going to be relatively negligible, because if you're putting up 1,000 homes and buying solar for that, you will be able to accommodate or experience a significant price break in the equipment. And given you have near zero duties coming in on solar equipment, I think we really need to have a new conversation on where the developers stand, what can be achieved, and what the public ends up with as a self-sustaining home. Efficiency equipment, as Jason put on to me just now, there are codes with the customs agency that once you're bringing in equipment that or material that has an energy efficiency value, there are reduced duties, reduced taxes related to those. So the overall energy package for a home trying to be efficient, or a developer trying to create an efficient home, is actually a very attractive prospect.
Chris, would developers build with efficiency and renewable energy in mind if it costs more initially, without building policy in place to force them to do so?
Sorry.
That's a good question.
It's a good question. It's a bottom line question, and it's going to, in many ways, depend on the type of developer and the type of development. If you're talking about developments where the developer is shooting after a fairly inelastic market, like for instance, the one that the PM wants them to target more, that $10 million market, there's not going to be an awful lot of flexibility in terms of price that could allow them to recover that additional million that Richard is saying they'll have to maybe sink into it to equip that house. They really are threading the needle very closely, and perhaps would be very leery of doing that kind of development in those situations. But I suppose for higher income homes, where maybe there's more elasticity in terms of the price point that a developer could actually tweak and still have a viable market, maybe they might make an economic decision in that regard. A lot might have to do with just how committed they feel to doing environmentally safe and renewable projects.
All right, just to say, Chris, that I think that with a thrust and a cost of $1 million, yes, that's 10% more on the value of the house. But it is not something that is
break a bank.
Yes, it's not something that was going to break the bank. And with the thrust through the National Housing Trust of providing the mortgages for these folks, and their program, the GPP program, where they buy the houses, it will be a built-in cost. And
in
the
fact,
$10 million for the house,
yes,
plus $1 million for the, because this makes absolute sense for the low-income person to not have, you know, rising costs for electricity.
Yes.
So, you know, I think that would be a win-win situation, and a win for the JPS as well. Because
And I think
in many situations there, you know, the grid gets tampered with. So this would reduce that propensity.
That risk.
Yes.
I think also, Mr. Wood, that bringing up the NHT is a valid point, because currently, if you have a mortgage and you want to have a solar system PV loan with the NHT, they force you to have been paying on that mortgage for at least 15 years before you qualify to get a solar PV loan. Not solar water heating, I'm talking solar PV. So that's a government policy that is not allowing the lowest cost lender in Jamaica to give their clients solar PV. So developers, including it in the cost of the home, like you just suggested, is the key. That is the key.
That must be an anomaly in the NHT's regulations here for some reason, but it doesn't really make sense, does it?
Well, it's been an anomaly we've been fighting for 15 years that they won't change.
Wow. Okay.
But it points to perhaps the need that the PM has underscored, that as developers, we're going to have to maybe be a bit more vocal in advocating that some of these change, because they're quite counterintuitive.
Yeah. Well, I think we're getting some frantic wrap-up signals, Chris.
I know they are, but I'm going to ask for 2 questions to be answered from the thing, because we have ignored the Q&A entirely.
Yes.
Someone wanted to know, are there smart homes actually being built in Jamaica today? Mr. Case?
You have elements of smartness being put into homes, but in terms of a comprehensive smart home, I would say no.
As you have defined it with water and electricity.
Well, even just on electricity, a completely smart home. So it's easy to integrate certain things into some level of automation, but for a fully controlled home, I'm not sure. So you see things like smart key locks to unlock doors. You have security system connected to homes now, and people using Alexa to turn on lights and different things like that. But you have elements of smartness, but the comprehensive smart home, I would say no.
And a colleague of mine, Nareen Small, asked, based on Mr. Case's presentation in relation to net billing, it appears we're almost at the maximum percentage designated for this. Are there any current plans to increase that percentage?
That would be MSET. That would be a policy.
That's yours.
Yes.
Ministry policy.
I wouldn't be able to speak to that.
That's a high policy. That's above your pay grade.
Yes, outside of my capacity.
Very well. As Mr. Wood is saying, there's a frantic wrap-up signaling being made, and sadly, we are going to have to bring our deliberations to an end. It has been particularly useful, this last segment. I struggled and wondered if we would finish strongly. I think we absolutely did. I think it's an area that has an awful lot of interest, because people realize where this world is going and where their electricity bills are going. And I think this is an imperative that we're going to have to deal with very, very soon, and in a more comprehensive way. So having said all of that, gentlemen, lady, I congratulate you on your participation in these in this event, and thank you on behalf of the association for your efforts expended. I think we're about to do our wrap up now. Mr. Wood, as the head cook and bottle washer, I'm going to turn that over to you to have those final words.
Thank you very much, Chris. And boy, I'm not the head cook and bottle washer. I'm merely the, what would you say now? The person sitting in the role of chairman for the time being. And it has certainly been a pleasure to be associated with particularly this webinar today. Thanks, of course, to our Prime Minister who took the time, and we know he's very busy, to address us this morning, making some very, very key points, reiterating the government's absolute importance that they put to our industry. And you know, we have been fortunate. This is the 5th of series of webinars, and we have had the first three we had opening addresses from the then Minister of Housing, Minister Charles, and then we had Minister Chuck. I know we have had the Prime Minister. So it's clear in this indication that the government is very serious and very supportive of whatever we can do to make our industry more efficient and to make people aware of what's possible. I'd like to thank you, Mr. Honeywell, for a wonderful job of moderator that you did. You certainly kept us moving, and you had everybody on their toes. Wonderful. Thank you so much. And to our presenters, ALTON Morgan, Ian Bennett, RICARDO Case, KADENE Campbell, and our panelists, DeLeon Smith, Chris Burgess, Richard May, Zachary Watson, Richard Mullings, and Jason Robinson. And of course, we couldn't do any of this without our sponsors. Gore Homes, BCIC, Hardware and Lumber, Jamaica Property Company, JMB Group, Jane Bank, DigiView, Wicon, Cement Company, Millennium Properties, Corwell Banker, Jamaica Mortgage Bank, Gian, JPS, National Housing Trust, all of whom have made these series of webinars possible, because part proceeds of these webinars, of course, goes towards our support of UTech students in the built environment. We provide stipends, scholarships, not really scholarships, but bursaries to them at the end of each year. And that's that time of the year again. So thank you all very much. Thank you particularly to those who took the time to tune in. We look forward to having our presentations continue next year, and we look forward to your participation. As this is the last one for this year, let us like to early wish you all Caesar's blessings and all the very best for the new year. Thanks to my hard-working team, Bertina McCauley at Accessible Data, and of course, our tireless Jamaica Developers Association Company Secretary, Caroline Simpson, without whom all of this would not have been possible. Thank you and take care.
Thank you very much.